Okay, everyone, good morning. My name is Max Disposti. I'm the board president. My pronouns him as, and I would like to welcome you to the Board of Behavioral Sciences board meeting today. Today is July 7, 2021, and the time is 9 a.m. This meeting is occurring at various locations pursuant to Executive Order N-08-21 that was dated on June 11, 2021. This public meeting will be held via WebEx platform, which is the one that you're seeing in front of you. Good morning, moderator. Could you please explain how we will be conducting the comments portion of this meeting, please?
Thank you very much. So to facilitate public comment, we will be utilizing the WebEx question and answer feature. When the board president indicates that it is time for public comment, I will turn on the question and answer feature, also referred to as the Q&A. Please note that the Q&A feature is a means for members of the comment to represent that they would like to make a verbal comment. However, if you are unable if you do not have a microphone, you may type your question. And also, if you are unable to type that you would like to make a comment, you may also use the raised hand feature. If any attendees utilize a profane name, they will not be called upon to prevent members of the public from being subjected to profane language. While you're free to express criticism or negative views for the sake of the members of the public participating on the call, please do not use profane language when making public comments to the board. For the sake of time, your public comments today will be limited to 1 minute, and I will give you a 15-second warning. And with that, I return the meeting over to the board president.
Thank you so much, moderator. Thank you so much. And now it's time for us to establish a quorum. Steve, could you please help us to do that? Thank you, Steve, and good morning.
Yes, good morning. I'm going to be playing Christina today, so I'm going to roll call here. So, Max Disposti?
Here.
Crystal Anthony?
Here.
Great, thank you. Deborah Brown?
Here.
Thank you. Ross Ehrlich?
Here.
Great. Susan Friedman?
Here.
Thank you. Christopher Jones?
Here.
Great. Jonathan Maddox?
Here.
Thank you. Kelly Ranasinghe?
Here.
Excellent. Wendy Strack?
Here.
Great. And Christina Wong?
Here.
Great. And Diana Hurwitz? I believe Diana was supposed to be on. She is absent right now. And Yvette will be absent today. So maybe we'll see Diana. Thank you. We've established one.
John Sovic is also present.
Oh, John Sovic. Oh my gosh. I apologize, John.
I see how today's
I
going to go.
had skipped over. I checked your name already off. No, it's going to go good. John present. Thank you, John.
Excuse me, this is the moderator. Sorry to interrupt, but Diana Herrick is in the meeting. I'm going to try to unmute her manually. Maybe she's having difficulty with that. So let me.
Okay.
You know what? I'm not able to unmute her.
Okay.
Thank you.
I can work with her on the side to see.
Thank you, Steve, and thank you, moderator. Maybe, yeah, we can work with Diana on the side so that we can perhaps help her out how to log back in. Usually logging out is the best way to do it and then come back in. Okay, good morning, everyone, again. So before we begin, I really would like to acknowledge that we have a very busy schedule today, which includes 3 petitions hearing. So I'm wanting to begin the petition here close to 10 o'clock. By saying that, I don't mean to limit any public conversation whatsoever, but just to be fair to all the people that have been waiting for today's session, I just, time is the essence. So it's just an encouragement. So we can move now to our agenda item number 2, which has to do with the public comments for items that are not in the agenda. Moderator, would you please open to the public to see if there are any public comments for people to address to the board today?
Thank you, Mr. Board President. I've opened up the question and answer panel. If any member of the public would like to make a comment, please type "I would like to make a comment" using the field in the lower right-hand corner of your screen and submit it to all panelists. We are displaying instructions and we will give you a moment.
Thank you, moderator.
This is the moderator. I see no requests for public comment and no raised hands. Would you like me to go ahead and close the Q&A panel?
Yes, please. Thank you.
You're welcome. It's closed.
And now we're moving to agenda item number 3, which where we're asking for any suggestion for future items that are not in the agenda. Again, moderator, please, would you like to open the inputs from the public again? Thank you.
Sure. So the question and answer panel is now available once again. If you would like to make a comment, please type "I would like to make a comment" using the field in the lower right-hand corner of your screen and submit it to all panelists, or you may raise your hand if you're unable to access the feature. We are displaying instructions for your reference and we'll give you a moment.
Thank you, moderator.
All right. I see no raised hands and no request for public comments. So shall I close the Q&A panel?
Yes, thank you. I would like to move to my fellow board members to see if they have any suggestions for items not in the agenda. For future items not in the agenda, excuse me. Okay, it looks like we're all on the same page this morning. Thank you, moderator. We can move now to our first agenda item, which is item number 4. Discussion and possible action regarding comments received during the 15 days public comments period on proposed revisions to supervision rulemaking. There was proposal to amend Title 16 California Code of Regulations, CCR, in section, excuse me. Christy, if you would like to help us, the floor is yours. Thank you so much.
A second 15-day public comment period that we held on the supervision regulations. So this regulatory package has been around for a while, so we're moving it through some of the final stages and just cleaning up little bits of the language. And so we did get some public comments on the most recent I'm sorry, this was the first 15-day public comment period. Our next agenda item is on a second 15-day public comment period that we'll be doing. So I apologize. This is the first 15-day public comment period we've already been through, and we did get some public comments. So you have a background here on what these supervision regulations would change. We're making some pretty major changes. We had originally a 45-day public comment period in early 2020. We did get comments and we responded to those comments. And then, like I said, we had additional changes to the text that the board approved in March of 2021. So the first comment that we received was from Kathleen Hawks. And she had a question about why LMFTs were not included in a section that was not part of the 15-day public comment period. When we do a 15-day public comment period on the most recent changes to the text, if the comments are not pertinent to those changes that are specified in that 15-day notice, technically, you know, it's considered not relevant, but we did decide to go ahead and respond to the comment so that just to give the commenter some information about it. So I'll go ahead and kind of go over what we responded to, even though it wasn't relevant to this 15-day notice. So she asked if LMFT should be included in the text that talks about treatment of couples and families by individuals pursuing LPCC licensure. She thought that LMFT should be included as an individual who could supervise. And they do not actually need to be listed because of their scope of practice. So The other license types have to be included, but the LMFTs do not. So they can supervise individuals who are pursuing their couples and families designation, who are pursuing LPCC licensure. We actually got 2 comments from Teresa Pardini. One, they came in through 2 different channels, and one of them was kind of a shorter paragraph, and then one was longer. And so the second one subsumed the first comment into it as well. So we're responding to it as one comment because they overlapped. This is another situation where most of the comment did not pertain to these changes in the 15-day notice, but we'll go ahead and go over it. Again, we responded to her concerns regardless. So, excuse me. She expressed concern that the additional requirements for supervisors and their employers place an undue burden on supervisors that will discourage supervisors from taking on supervisees. She's concerned about it creating a, excuse me, a supervisor shortage, and may reduce the production of new generations of therapists due to a lack of supervisors at a time when COVID has increased the need for therapy. So there are some additional requirements for supervisors that were proposed in this 15-day notice. The one additional requirement would have been to have supervisors notify the board within 60 days of them being no longer qualified to supervise. We don't feel that would have been a significant burden to supervisors, as it would have been just a simple communication sent to the board through the mail. However, this language, which we had originally proposed for the purpose of maintaining a current list of supervisors, is actually proposed to be stricken from the text for other reasons. So we're going to talk about that actually in the next agenda item. So, and we'll talk about the reasons for that. So there are, and as I said, there are no other additional requirements in that modified text. And we think she was probably referring to the originally proposed text, which did contain new requirements. But again, that was already, it was subject to an very extensive public development process and a 45-day public comment period. And we did very carefully weigh those changes with public protection needs. And we determined that it was not anticipated to create a significant burden on either. The commenter also expressed concern that additional requirements for agency investigation and certification of the validity of paperwork, in addition to the legal responsibility, will overload hiring agencies, and that we made no mention of the extra work in our assessment of costs, and believe that we will be shifting the bulk of our job and legal responsibility of determining licensure qualifications of associates to the agencies, and that would be costly and legally worrisome. She had concerns about how the board proposes that the agencies investigate and monitor supervisor statements, since the board has access to licensure information of supervisors and individual agencies do not. Kind of goes on about about the responsibilities, and that these agencies are usually understaffed nonprofits who provide services to underserved communities surviving on a minimal budget. So again, we reviewed this comment. We don't recommend any changes. Again, it's one that's outside of the public comment. It doesn't pertain to this public comment period. We do very much understand the challenges currently facing agencies, but we also do not feel these regulations would add to their burden. The current statute, something that's not being modified, it already requires employers that are not a private practice to sign a written oversight agreement with a supervisor in certain situations. We are making some modifications to the written oversight agreement in the regulations, but it's not anything that's burdensome. It's just some minor changes. So it's not anything new that they have to complete. As to her concerns about investigation and certification validity of paperwork, there's nothing new there either. Agencies and employers do check the licenses of those they hire, although that's not something that the board enforces. So I'm not sure what she was really referring. Maybe there was a misunderstanding of the text. And then in terms of forms that supervisors complete, the supervisor responsibility statements are a current regulatory requirement. The proposed regulations do modify them, but not in a way that significantly increases a supervisor's or agency's workload. It's this new, it's a supervisor self-assessment form that is designed to make it clear for supervisors to understand their roles and responsibilities so that they're informed And so that they don't inadvertently violate the law, it really kind of brings the law together in one place for them to review and go over. So it's not expected to create a significant burden. It has a lot of benefits to it. So again, we carefully weighed these changes with public protection needs and felt that, again, subject to a 45-day public comment period, extensive development process. So those are the proposed responses to the public comments. So the job of the board today is determine if you feel that these responses are adequate, and if so, we have a recommendation for a motion. And if not, then what changes you think we should make in our responses to the comments.
Thank you, Christy. Thank you for helping us understanding and articulating the answer as well. Board members, any questions, observations, adjustments, suggestions? Okay. Moderator, if we can get the input from the public to see if there are any comments, please. Thank you.
Thank you. I have opened up the Q&A panel. If any member of the public would like to comment, please type. I would like to make a comment using the field in the lower right-hand corner of your screen and submit it to all panelists. We are displaying instructions. If you don't have access to this panel, feel free to raise your hand and we can unmute you to make your comment. We'll give you a moment. This is the moderator. I see no request for comment. Shall I close the Q&A panel?
Yes, thank you. Thank you so
Okay,
much, moderator.
You're welcome.
Christy Berger, if I'm correct, I think the board needs to vote on this. Am I right?
Yes, correct.
Thank
So
you.
we have a recommended motion in the memo.
Right. Thank you so much. Then I would like to see if any board member have motions to submit that reflects the comments that Christy has read today.
I can make a motion to
Thank you.
approve the proposed responses to public comments received and direct staff to make any board approved changes and any technical or non-substantive changes needed to complete the rulemaking process.
Thank you,
I'll
Christine.
second that. I'll second that.
Who is seconding? Please say.
Was that Deborah?
Deborah Brown. Okay, thank you, Deborah. Okay, we have a motion on the floor. Steve, thank you for helping us today.
Okay. So we have the motion, and as they call your name, let me know your vote. Max Disposti,
Yes.
Crystal Anthony,
Yes.
Deborah Brown,
Yes.
Ross Ehrlich,
Yes.
Susan Friedman,
Yes.
Diana Herwick,
Yes.
Christopher Jones, Jonathan Maddox,
Yes.
Kelly Ranasinghe,
Yes.
John Sovic,
Yes.
Wendy Strack,
Yes.
and Christina Wong.
Yes.
Great, motion passes. Thank you.
Thank you, Steve. Thank you, staff. Christy Berger, we're moving to the fifth items of our agenda, which is the discussion and possible action regarding additional proposed revisions to supervisions, rulemaking proposal to amend Title 16 CCR sections. Thank you again for
Yes.
helping us through this.
Oh, you're very welcome. So this is on the same regulation proposal. This is some text changes that we have identified for a second 15-day public comment period. So partially because we're having to, we had to respond to those public comments, and we had a delay because we didn't have a quorum at the last meeting. It was pushing out our anticipated effective date of these regulations by 6 months to, instead of July 1st, we're looking at a January 1st, 2022 date. So most of the changes that you'll see in here are just pushing those dates out correspondingly. but I'll go over the changes. So, and as we were reviewing for those dates, we did identify a couple of other minor changes, as well as the one change that I talked about in the last memo. This is there are a lot of law sections that we're changing, and we're always looking over the language over and over again, trying to see what how we can make it better. So the first change would be to sections 1820A, 1833A, and 1869A, and so these are changes that are mirrored for each of the license types. So it's the same exact thing for LPCC, LMFT, and LCSW, the individuals pursuing licensure. So for the written oversight agreement, we want to streamline the text of the regulations just by referring back to the statute that requires a written oversight agreement. It was duplicating it and wording it in a way that was a little different from statute. Not really any big difference, but we just didn't want to have any confusion and make people think it was somehow different. So we felt that it was better to just refer back to the statute and just add some language to clarify that what the regulations are doing contain some additional provisions and how this agreement is to be executed. So like, for example, that this shall be provided to the supervisee so that they can use it when they apply for licensure. So things like that are specified. And we just kind of, in a prior version, we had some text that clarifies that the written oversight agreement pertains to the supervisee's employer, not to be confused with the supervisor's employer. So that's a change that you'll see where we just move that text to another section to make it clearer. So this next one's a date change. The supervisor self-assessment report, again, date changes. The one thing that is a significant change is the list of supervisors that where we would have required supervisors to notify the board within 60 days of being no longer qualified to supervisors so that we can remove them from the list. So this list that we had proposed that we start maintaining we planned this for internal use only. And so it's not a public list, it's just something that staff can use. And we realized that we really did not want individuals removing themselves from the list because there's several reasons for that. So we are proposing to strike that text that would require them to notify us. So the reasons we need to keep a list, even if it's not current, is because when we're looking at hours of experience submitted by applicants, those hours can be up to 6 years old, or even more in the case of MFT practicum hours. So we need to be able to look back and see, even if they're not supervising right now, were they 6 years ago? In addition, the staff would be using them when we're performing audits of supervisor records, which they have to maintain for 7 years. So again, looking to the past, and then we would also use it as a past workforce data. So again, we're recommending striking that text. And because it's not a public list, there wouldn't be any confusion to the public by getting rid of that requirement. And so the last one is just, again, a date change. So that's really it.
Thank you, Christy. I think in my understanding also, based on previous conversation, is really we're trying to create consistency in the oversight, right, the responsibility of supervision, because at the beginning we didn't have any. So we're trying to be consistent across the board, internally, externally, about what to put in place so that we can make ourselves accountable, obviously, when we get back to people about the hours and everything else. So I really appreciate this.
Yes.
Any board member, you're welcome. Any board member feedback and inputs, if there are any? Okay. I would like, moderator, if we can open to the public and see if there are any inputs from the public as well.
Thank you, Mr. Board President. I have opened up the Q&A panel. If any member of the public would like to make a comment, please type "I would like to make a comment" using the field in the lower right-hand corner of your screen and submit it to all panelists. We are displaying instructions. You may also raise your hand if you do not have access to that feature. We'll give you a moment. All right, I do not see any requests for public comment. Mr. Board President, would you like me to close the Q&A panel?
Yes, thank you so much.
You're welcome.
And back to the board. Is there a motion? I would like actually to make a motion to follow the recommendations of Christy in regards to scratching the, is that the right word, Christy? You were deleting a portion of the amendment, right? Correct? Okay, I would like to make a motion to support staff recommendations.
Max, this is Sabina. Can you hear me?
Yes, Sabina, please help me.
Sorry, there's an actual well-crafted motion in the recommendation of the memo. If you scroll down, I'm happy to read it if you would like.
Please do.
Sure.
Yes, I have papers in front of me.
That's okay. So the motion will be to approve the amended regulation text and initiate a 15-day public comment period. Additionally, if no adverse comments are received during the public comment period, or if any adverse comments received are irrelevant to the amended regulation text, to delegate to the executive officer the authority to make any technical or non-substantive changes that may be required in completing the rulemaking file.
Our legal counsel, Sabina, thank you so much. That's exactly what I meant.
I know you did.
Thank you for reading it for us this morning. I really appreciate it. Welcome. I didn't say hi this morning to you as well. Okay, I made a motion on the floor. Anyone would like to second?
I'll second.
I believe that was Susan. Am I correct? Yes, Susan Freeman seconded the motion. I think we can vote. Unless there are any other comments on the proposed motion. Okay. Steve, if you can help us with the count. Thank you so much.
Yes. Okay, here we go with the vote. Max Disposti,
Yes.
Crystal Anthony,
Yes.
Deborah Brown,
Yes.
Ross Ehrlich,
Yes.
Diana Herwick,
Yes.
Christopher Jones,
Yes.
Jonathan Maddox,
Yes.
Kelly Ranasinghe,
Yes.
John Sovic,
Yes.
Wendy Streck,
Yes.
Christina Wong.
Yes.
Wong.
Yes.
Christina Wong. Motion passes.
Thank you, Steve. Thank you, board members. We're moving now to agenda item number 6, the discussion and possible recommendation regarding Assembly Bill 107 on licensures of veterans and military spouses. Thank you, Christy, again.
That's going to be me, Roseanne.
Oh, Roseanne, I'm sorry. Yes.
No,
Hi,
no
Roseanne.
worries. We'll jump right on into this. AB 107 would require all licensing boards within the Department of Consumer Affairs to issue temporary licenses to military spouses if they meet certain requirements. The board had to consider this bill back in its meeting in May and had taken an oppose unless amended position. However, there's been a somewhat significant amendment, so it needs to revisit to see what the board's thoughts are now. So currently, I think you already know, a board within DCA is already required to expedite the initial licensing process for a honorably discharged U.S. military member or someone who is married to or in a domestic partnership with an active U.S. military member who's assigned in California. The board also has a streamlined licensure by credential process for all current license holders in another state who have been licensed at least 2 years. That sets up a process for that person to have a streamlined process for licensure. So this particular bill would require all boards, including this board, to issue a temporary license to somebody who's married in domestic or in a domestic partnership with somebody who is assigned to duty in California. They have to have a current active and unrestricted license in their other state. They have to submit an application to the board attesting that they meet the requirements for a temporary license. They have to not have committed any crimes that would be subject to denial for licensure. They have to fingerprint, and then there's a new recent amendment that was just recently made. They would also now need to pass a California law and ethics exam if the board requires one, which this one does. And then if all of those were met, the board would be required to issue a temporary license within 30 days of receiving documentation that the person has met the requirements. And the temporary license would be good for 12 months after issuance, upon issuance of an expedited official license or standard license, whichever occurs first. So about the current board process, I said we already have a license by credential process that kind of streamlines the process for all out-of-state licensees. We also are required to expedite for a military member. So a couple of concerns that staff have still hold. It doesn't necessarily require a check before the issuance of the temporary license that all the licensing requirements of the other state be substantially equivalent to that in California. The clinical exam would not have been passed yet, although the law and ethics now the bill requires it would have. And so some concerns there about that, about continuity of care. At the time that the board took a position in May, they took the position of oppose unless amended. The board cited concerns that because California has a uniquely diverse environment, the practitioners really need to be aware of the California climate and the unique diversity of the state. Otherwise, the person's license could be jeopardized and public protection could be jeopardized. So that has changed a little bit since this. Now the bill requires passage of the California Law and Ethics exam, so the person would at least have to pass that first exam. They would not have necessarily had to take the California Cultures coursework yet, or the California Law and Ethics course. If they could pass the exam, they could get the temporary license. And so a little bit of implementation concerns about how that would work if they needed to register as an associate and things like that, although other boards also have temporary licenses and have worked it out. So wanted to open this back up for further discussion to see if the position should be updated or if it should stand as it is.
Thank you so much, Roseanne. Yeah, Roseanne, we had a very comprehensive conversation on PNA and also in the board meeting last May, as you mentioned. So fellow board members, any inputs, suggestions, considerations?
I actually have a question. Being a military veteran, I'm curious. So what is the what happens to a licensee? Well, here's my question. A lot of times out-of-state residents are actually stationed in California for longer than 12 months. They may be here 2 years, 3 years, depending on the branch of the military they're in or what their particular job is. So what is the recourse of a out-of-state spouse who gets that 12-month temporary license if their spouse is stationed here longer than a year? Do they actually have to move forward with getting an actual license and getting the hours and all that? Or is there a mechanism in place for them to renew that if they're only going to be here 2 years and they clearly are leaving when their station is redeployed somewhere else?
Thanks, Jonathan. It would be 12 months. The temporary license is only valid for 12 months. So it can't be renewed. They would have to have proceeded with getting their regular license. And so most applicants would probably would fall under the portability and would be able to do that fairly easily. If they hadn't been licensed in their other state for 2 years, then they may need to register as an associate and gain some hours, so it might take them a little bit longer, and they wouldn't be subject to the streamlined licensure process.
I was going to say, I think the last time we had this discussion, like, I'm glad that the law and ethics piece got added, but I think one of the things that kept coming up from the board was more about like cultural competence, because we are so progressive in California with certain legislation and other laws and stuff like that. And I think that we serve a wide variety of communities, and not the whole country is that way. And so I guess, like, how are we addressing cultural competence? Because I know that that was one of the things that we had brought up actually as a concern.
Correct. And Crystal, just for the record, some people cannot see us. Crystal Anthony was just placing a comment. Thank you, Crystal.
Oh, sorry. Oops.
Yeah, it's okay. It's okay. No worries.
Hi, this is John Sovek. And I want to follow up on what Crystal was saying. I do still have concerns. I think adding the law and ethics is definitely a move in the right direction. But I think we are a vast state with all kinds of cultures and experiences going on here. We also support different communities different than other parts of the US do. So I would have concerns if you look at things like reparative therapy is not okay for adolescents here in California. It is still in other states around the country. How would we move into something like that to keep our public protected? So I think it's definitely a step in the right direction, but I do still have this leaning towards oppose because I do think there are lots and lots of layers of this that aren't necessarily aren't being addressed under our license and what our licensees do.
Thank you, John.
Um,
Anyone else?
yes, Max, this is Kelly. And I think from the tenor of the discussion last time, I think it's clear that the board's quarrel is not really with the need for veterans and military spouses to have some mechanism for engaging in practice, which is well protected. It is, as Crystal and Mr. Sovek also said, Ms. Anthony and Mr. Sovek also said, the idea of public protection. We have 50 states, and 30 of those still allow conversion therapy. That is a significant risk because conversion therapy is illegal in California. And there is definitely a cultural divide in the mechanisms of service providing in mental health between our state and other states. Additionally, under Section 3 of the recommendation to the board, one thing that is a great cause for concern of me is the idea that the educational institution, which forms the basis for the master's or doctoral degree, be from an accredited institution. That is a deep concern. And with that, I would submit.
Thank you so much. Susan? Susan Freeman?
I don't mean this in any negative way at all, but I do think that very often military families are at a particular base. Let's say they're in Oceanside or someplace like that. I think they operate within their own small community, and that people who have a license from another state may just offer their services within that community without paying any attention to what the laws are in California. I may be totally wrong about that, but from what I've observed, the way people who are stationed here temporarily operate, they usually just contain themselves to their own community.
Thank you, Susan.
I don't know if that's a problem or not.
Well, I don't mean to answer that because I by any means, but I think it's a different challenge, I would say, that which the board doesn't have much jurisdictions in terms of checking who's serving whom. But I don't mean that to be an answer, Susan. I don't know, Roseanne, if you would like to articulate about what has been just said, just for clarification of what this does or doesn't do.
Right.
Yeah.
The bill basically would require passage of a law and ethics exam. So they would have to have some knowledge of California law and ethics. But basically, if they were going for even if they were getting a streamlined or expedited license through a portability, because they've been licensed for 2 years, they would not have to take the California Cultures course, the California Law and Ethics coursework, or the Child Abuse and Assessment California specific coursework. So there would be components missing. If they'd only been licensed less than 2 years, then there might be even more coursework needing. So they would have to show that they can pass the California Law and Ethics class, but that is that the same as taking all of that more in-depth coursework? That's a good question.
Right. And thank you, Roseanne. If I recall the conversation we had past in May, they were in one way trying to create consistency with other boards where they have allowed a certain expedite process for temporary licensing. Let's remember, we're talking about temporary licensing, not a permanent licensing. That it's not like cutting corners on the final license, because people had to apply for the whole license at the end of the year. Just for clarification, And I remember we were going back and forth in regards to, which I share the same concern of my fellow board members in regards to, how much are we opening a possible liabilities for our consumers when, not all those courses have been taken and not all the access has been granted in terms of education. So any more comments, or if anyone would like to, Roseanne, what would be the motion again? I mean, if there was a motion in support, what would be the staff recommendation? Yes.
So if you wanted to, it sounds like it's possible that the board is leaning still toward, due to the concerns I've heard cited, that you're leaning toward another oppose unless amended position. And if that's the case, then the last time the position was opposed unless amended to remove the board from the provisions of the bill.
I actually have a question, another question.
Thank you, Jonathan. Go ahead.
Is there, as it's currently written, is there a requirement that, let's say this moves forward, that this temporary licensee give notification to the actual client that they have a temporary license, that they're from a particular state, or not even in that detail, but that they need to inform in written documentation and have the client sign something where they acknowledge that they're aware that this is a temporary license, so that they're aware that kind of just like with a trainee or someone else, you inform them, hey, I am a student, I'm working under this supervisor. If there's any challenges or concerns, you can speak to my supervisor. It seems like it would be prudent to have them give some sort of notification that the client signs where they're aware that this is someone from another state, which might then lend them to ask certain questions before they engage in care with that person.
No, that is not a current requirement of the bill.
I mean, I don't know what other board members think, but I think that would be a reasonable sort of piece of informed consent, that the client would actually know that up front. I'd be curious what other people think.
John,
Thank you.
John and Chris has their hands up.
Thank you, Christina. John?
That was left over from my previous comment.
Thank you, John. And then I believe Chris, right?
Yes, actually, I agree with Mr. Maddox. I do think that there probably should be some sort of informed consent with regards to understanding that that the public is working with someone who hasn't been trained in California. And I'd like to actually ask another question and take it a step further. What about the discipline side of it? I mean, our discipline process takes a while. So if we have if there's a complaint against someone with an out-of-state license that's temporary for a year, and they go through that process, there's the possibility that they won't be here when that comes to fruition. I don't know if that's an issue or not. I mean, BBS licensees can quit and move in at any point in their life, but I don't know if that's something that we've thought about or need to take into consideration.
Thank you, Chris. That's a great question. Roseanne, would you like to help us with that?
That is a really great point. And our discipline process is slow. If they didn't proceed with the licensure, I mean, we could still, I believe, and Sabina, correct me if I'm wrong, we can still pursue disciplinary action on a license that's expired or no longer active. However, is there much point in doing so? If the discipline was pursued and they wanted to come back later, that would still be on the record. But yeah, if they don't pursue the license, there's not the discipline. I mean, it's just kind of would move forward, but they aren't practicing anyways.
So I'd like to make a motion.
Christina Wong.
Yes, I'd like to make a motion, to recommend that we continue that the oppose unless amended and require, the author to remove BBS, from the bill. I mean, it's the same motion like last time, that I think that's what I'm hearing. That's the direction we're heading for.
John
I'd like
Slavek?
to second that.
Okay, thank you. So what I would like to do before we continue, I would like to open, since we have a motion on the floor, I would like to open to the public to see if there are any comments or feedback. well, we can go back to board comments in case there are any. So, moderator, thank you so much. If you can please help to open to the public, that would be great.
Thank you, Mr. Board President. I've opened up the Q&A panel. If any member of the public would like to make a comment, please type "I would like to make a comment" using the field in the lower right-hand corner of your screen and submit it to all panelists. We are displaying instructions, and if you do not have access to that feature, you may use the *3 and raise your hand. All right, I do not see any requests for public comment at this time. Shall I close the Q&A panel?
Yes, sure. Thank you. Thank you so
You're
much.
welcome.
So back to the board. I know we have a motion on the floor from Christina Wong and second by Dr. John Sabat. The motion is to oppose unless amended, which is the similar motion that we passed on May. Are there any other additional recommendations, comments on the motion on the floor? Okay, then at this point,
Wendy,
Mr. Chair,
comment.
sorry, was trying to figure out how to raise my hand and forgot, but just a question for Christina. Do you want to include Jonathan's point about notification, informed consent in the motion?
Go ahead, Roseanne. Roseanne, you voted.
And with the author's office and bring that point up too. I'll tell them, you know, the motion is to be removed from the bill, and these are the concerns, and that will be one of them.
Okay, I see. Thank you.
Thank you, Wendy. Again, motion on the floor. Any other comments? Otherwise, Steve, if we can call the vote. Thank you.
Okay, here we go. Max Disposti?
Yes.
Okay. Crystal Anthony?
Yes.
Deborah Brown?
Yes.
Great. Ross Ehrlich?
Yes.
Great. Susan Friedman?
Yes.
Diana Hurwitz?
Yes.
Christopher Jones? I think I heard a yes. Okay. Jonathan Maddox?
Yes.
Kelly Ranasinghe?
Yes.
John Sovik?
Yes.
Wendy Streck?
Yes.
And Christina Wong.
Yes.
Thank you. Motion passes.
Motion carries. Thank you so much, Steve. We're moving to agenda number 7. Discussion and possible recommendation regarding Assembly Bill 468 for emotional support dogs. Roseanne,
Yes.
thank you again.
Yes, so AB 468 has to do with emotional support dogs. This is kind of a topic that we haven't seen a bill on this really before. And it is a topic that affects the board's enforcement unit from time to time. So I thought it was important to bring it to you. The bill would require a healthcare practitioner who provides documentation about an individual's need for an emotional support dog to comply with certain requirements. And the state law existing has certain definitions in law about guide dogs, signal dogs, and service dogs that are used to help out individuals with disabilities. But there's also another category, emotional support dogs, that have a more general purpose, and they're not that is not as well defined. And some of our licensees do issue certifications for these dogs. So this particular bill, the portion that's relevant to the board is the bill proposes prohibiting a health practitioner from providing documentation regarding an individual's need for an emotional support dog unless they comply with certain criteria. They would need to have a valid active license that includes the effective date, license number, jurisdiction, and type of professional license in the emotional support dog documentation. they would need to provide the license to provide professional services in the scope of a license in the jurisdiction where the documentation is provided. So they can't be a licensee here and providing it to other states. There needs to be an established client-provider relationship with the individual for at least 30 days before providing the documentation regarding the need for the support dog. And they need to complete a clinical evaluation of the individual regarding the need for an emotional support dog. Another thing that's included right now that the author has kind of asked what for feedback from the board, if there's any concerns with, they have in there that they would like to have them provide verbal or written notice to the individual that knowingly and fraudulently representing oneself to be the owner or trainer of any canine license qualified or identified as a guide, service, or signal dog is a misdemeanor. And that's just so that the person that's receiving the dog is aware that if they're passing it off as something that's a more regulated type of dog, that's against the law. And so the bill states that if a healthcare practitioner violates any of the provisions that I've just listed, they may be subject to discipline from their licensing board. And that's a big change because before it's kind of been unclear who would take disciplinary action. The board didn't have the explicit authority. And then the bill also goes on to state that a person knowingly or fraudulently representing or selling an emotional support dog as being entitled to all the rights and privileges as a guide, signal, or service dog is subject to certain civil penalties ranging from $500 to $2,500. And that would be brought by the attorney general, or district attorney, or a county council or city attorney. And then the bill provides a definition of an emotional support dog as a dog intended to provide comfort or emotional support, and it does not meet the definition of a guide, signal, or service dog. So as I said, the board occasionally receives complaints about its licensees providing emotional support dog certifications. Usually the complaints come from landlords who are upset that this person is providing them a certificate about having an emotional support animal. In most cases, the board's unable to take enforcement action because of review of the records requires consent of the clients. And so there are some provisions of this bill that would be helpful to our enforcement unit. It explicitly states that the board can take enforcement action if certain provisions of the bill are violated. Right now, the board can take disciplinary action, but only if unprofessional conduct like fraud or gross negligence can be demonstrated. And the amendments also clarify that if there's a violation that's not under the jurisdiction of the board, it tells us who to point who's responsible for taking disciplinary action. So if somebody calls and complains right now, and it's not something that's under the jurisdiction of the board, it's not really clear to our enforcement unit where they should go. Where do we point them? And this would say that it's the attorney general, or district attorney, or county or city council. So we have had, I've put a couple of case examples in the notice. Board of Behavioral Sciences and Board of Psychology have both had a case where there was types of unprofessional conduct, gross negligence, failure to maintain confidentiality, things like that, that was, we took disciplinary action because those could be cited, but not in every case can that be done. And so I will open it up for discussion.
Thank you, Roseanne. Wow, so much to unpack here. Any board member, any comments?
Can I say something? It's Crystal, Anthony.
Thank you, Crystal.
What I've seen, because I've seen these before, I've never done them, but I've seen them before, and they're given, it's like a letter from the therapist, and then it like the psychology report has to show like what they have, like what their diagnosis is and stuff. But then the other piece that is often given to people is like a thing that they show their landlord, which it protects their confidentiality, which basically isn't saying like this person has PTSD, but this person like has been evaluated and does have an emotional support dog. I'm not sure like who we're protecting. Are we protecting the person that we're treating, which needs an emotional support dog, or is this bill protecting the landlords that are upset that this person is getting an emotional support dog? So it's hard for me to want to like punish, I guess, a therapist for helping a person get an emotional support, if they already have a dog, having that person have an emotional support dog. And then the people that are doing the complaints are the landlords because they're pissed off that they're not able to say, no, you can't come. And really that's a money factor, because I don't know if the board knows this, but they can't charge you for your pet when you have an emotional support dog. So like a landlord can't charge you to have a pet that's an emotional support dog. So I feel like this is like actually something that's like more convoluted and more, there's more to it than just like, are we regulating emotional support dog therapy, person that's evaluating for treatment type thing. So I guess my question is like, who are we protecting? Because I'm kind of confused right now by what the verbiage is and even the examples that are being given.
Thank you, Crystal. Very, very valid questions. I don't know if Rosanna, you want to say anything today, otherwise we continue the conversation as if you feel like there is a need.
I think that that is a valid question. I know that we get some cases where, you know, we find people are issuing these letters and they aren't really establishing a relationship with the client, and so there are some public protection concerns there potentially. And I think that the author's office would state, you know, that it's not helpful to people who have the actually defined guide and service dogs if there's these other dogs being passed off, but definitely I see the validity to the questions. And so the board does not have to take a position on this bill if they do not like, but I thought it was relevant to bring it forward so that you can be part of the discussion if you would like.
Thank you.
Max,
go ahead, Kelly. Yes.
So I'm going to join in Crystal's comments on this, and I'm particularly concerned that this bill is supported by the California Apartment Association and the Western Manufactured Housing Communities Association. We're not a foil for landlords. We are not intended to be used as a foil for landlords. And also, I would note that the process of getting a full diagnosis, going through a psychiatrist and psychotherapist, getting a service dog, it is not inexpensive. A lot of people simply have ESAs because they have no other choice. They can't go to a psychiatrist or a therapist, or they don't have access to one. And so their method of therapy is their cat, you know, which is a perfectly normal and reasonable method of emotional support. So my concern with this bill, and first of all, I also think that there is a mechanism under the criminal code for prosecuting and enforcing the improper use of guide dogs, is that we're sort of being pushed into an area where we are acting as a foil for a financial interest. That is not the purpose of the board. We are here for public protection. So that's my comments.
Thank you, Kelly. I wanted to speak to, but I don't know if I'm missing anyone before me, so forgive me. I'm trying to still figure out how to put you all in one place in terms
Thanks,
of
Jonathan.
This is Ross. I also want to give a minute.
So Ross and Jonathan and then myself, is that okay? Yeah. Go ahead, Ross.
Yeah, I just wanted to, also agree with previous board members and note that the bill, the language of the bill, what it's seeking to do really is putting more onus on treatment providers and people receiving the treatment. And I just, again, I don't know that it's protecting, consumer interests and doing what we need to be doing. So for those reasons, I would oppose this.
Thank you, Ross. Jonathan?
Yeah, so I was just curious. So, and you can correct me if I'm wrong. If I'm understanding correctly, practitioners are already doing this, like they are already writing these letters and providing this service across the state. So this is an established practice, correct?
That's correct. Yes.
I guess I guess I don't have for lack of a better metaphor, I don't have a dog in the fight. My curiosity is like, just what qualifications does a practitioner have to make a determination that someone needs a emotional support animal? I mean, I'm a licensed MFT. I don't know what to ask or do. I mean, I could acknowledge and maybe diagnose someone with an anxiety disorder, but in order for me I can't necessarily say that a dog or a cat is a great intervention for that. So I'm just curious, like, is there a best practice? Is there a training for this? Or anybody can do it and everybody's available to do it? I guess that's just my question.
Can I say, I'm sorry, it's Crystal Anthony. I'm sorry, because I know Max is next, but I just wanted to respond to Jonathan. my understanding, because I agree with you. I'm a licensed clinical social worker, and I wouldn't want to. I don't put my license that's not my expertise is emotional support animals, and but I have had people that have done that, and they go through a whole psychological assessment. It's like a person that gets psychologically evaluated, and they go through all the different types of symptoms and different like reasoning. Then they talk to somebody who's a licensed person, and I don't know what the qualifications are of that person other than that they are a licensed practitioner. And I think like again, I don't even think that's what this bill is doing. I think this bill is like trying to punish the therapists that are helping people get these emotional support animal pieces. It's, that's I think where my issue. I'm opposing it. So
Okay, Crystal. I know Roseanne wanted to answer as well. Roseanne, I saw you interjecting after Jonathan.
Crystal did a great job. I mean, there are trainings you can take, but there's no, I mean, it has a scope of competence question. If you are competent, you can do it. I think that the bill, what the author would probably tell you they're trying to do it is to kind of make sure that people really that are doing this really have the established client relationship and are not just charging for letters, and making sure that there's a little bit more of a relationship behind that. And so that's all I would have to say in that case.
Thank you.
Okay. I mean, while I agree with everyone that other people have said, I mean, that doesn't seem unreasonable, but I would agree. It doesn't seem like that's what the intention is here, but it seems like as a board, I mean, that at some point might be something to look at, but yeah, I agree.
Right. So I share the same sentiment that's been said. I would like to say more. There is a tendency of gatekeeping the service providers in the 30 days access evaluation. I mean, it's based on what? There is not even scientific research that can prove that this bill is going to resolve that. I see the punishment aspect of it. Also, in the clients that we provide at my own center, there is a lot of people that use emotional dogs for a lot of reasons, and many of them don't have access. Let's remember, not everyone has access to a therapist. They will provide them an excuse not to go to the restaurant, but to stay with the animals where they would like to live, which is a very, very tendency in a lot of low-income housing where people are suffering, struggling, and they want their pets as a companion. I have a pet. I will have a crisis if someone would tell me I can't have it in an apartment. So beyond that, I think it's really the intent is wrong. It doesn't answer the questions that we are saying, and there is a legislative problem about jurisdictions who's reinforcing and why and how. And like Crystal was saying, the therapists are put under fire for doing something that's actually even their job of reassuring and creating a safe environment around the clients that are protecting and supporting. So I think I would like to oppose the bill, not just not take a stand, because they need to hear that the mental health community has a strong stand against this bill. It's not about amending, it's about really revisiting the whole, unpacking the whole where the bill is coming from, the intent of the bill. So I would like to make a motion to oppose the bill and for how it stands.
Max, before we do that, can I just say one more thing? And then I'm done.
Sure.
It would seem to me if they were legitimately wanting to address this issue, that they would address it on the side of where people may actually purchase the vests that say this is a service animal or things like that.
Right.
Creating criteria for that and then addressing it there rather than with the practitioners, because that doesn't seem.
They do have vests. They do have vests, and it does.
What I'm saying is that I think you can go to a flea market and get a vest. I mean, not to minimize it, but
we can say
everybody sells them, is what I'm saying.
Can I say something?
And I just
okay, hold on, one at a time, because Jonathan and Anthony, you were overlapping each other, so it couldn't come through. So I want to make sure the public has the opportunity to hear you both. Anthony, you were Crystal, you were answering to Jonathan, and then Christina.
I just wanted to second you, but I think Christina had a comment.
Okay.
Yes, I have a big comment. So so working for the county for so many years, and honestly, we have seen so many cases, that they come to the therapist, and ask for a letter, and, and whether we have an established relationship or not, And so I think, because, now so I think I want to point out, one, this is a very common practice, may not be, within, the other, licensed therapist practice before in my county, very common. Second thing is that, the whole concept about service dog, emotional support dog, and, what is the other one? The signal dog, they are massively confusing because even for our discussion, what really is the purpose, of that emotional support dog, even within our discussion is not really clear, because really, the emotional support dog's only purpose, is for the housing. And yet, I think, the very important phenomenon, that has been happening is that people do abuse, that the different category, taking advantage of it. And so I think, I totally get, where the protection is coming from. And I think it's not just about the landlord, it's not just about the licensees, but really it's about the general public also. And so, so I think the bottom line is that, I myself, I might be the only dissenting voice here, but I really feel that, the intent, of the bill is also a good, a step of the right direction, to put some mechanism and put some, clarity in place. What really is about, this kind of like, the legal, well, I take the word legal out, what really is about this particular letter? What really is about the role, of the licensees, or the associates, that would be writing this letter. And so, so the implementation might be problematic, because, that's obviously, what you all, talked about. But I think, I personally think that, the intent is really important to support, just because that, because of the abuse. And you can see that, those two cases, that cited, from, by Roseanne and, and there are people charging money, who just write the letter. It is a good business. And so, so are you going to, to view this as, a way that, that is acceptable? So I think the board has a really important role to consider, where we stand, in terms of this kind of practice, which has been existing. And there's only one we know, and God knows how many more out there. So that's my 2 cents.
Christina, since I made the motion, I would like to certainly incorporate the sentiment, but I think this bill does exactly the opposite of what you're saying. It's actually creating even more challenges. And also, I don't think it has to do only with housing. Here in Oceanside, where we live, we have a lot of veterans with PTSD that they go with their emotional dogs everywhere. They're not asking for any special rights. I mean, I don't see the abuse per se. I know there are a lot of organizations for the guidance dogs are really upset when people act like they have a vest on their animals, they have access to spaces, and then creates a confusion between, those that really, really need it. But it's not our place to a bill to define that. It definitely has to do with the ethics of the providers. I don't think this bill does any of it, though. So I concur with what you're saying. I don't mean to dismiss it, but this bill actually opens another can of worms and creates even more challenges. So I stand with my position, but I recognize the sentiment behind your intervention because I understand there is a dynamic, but this bill that actually implements, it divides even more from who can, who can't, and based on what, when there is no scientific support behind it. So I stand to the motions. I don't know if there was a second. I'm sorry, I missed that.
I seconded it.
Okay.
Crystal.
I would like to open to the public, and then we can come back in case there are any other suggestions. Moderator, thank you.
Thank you, Mr. Board President. I have opened up the Q&A panel. If any member of the public would like to make a comment, please type "I would like to make a comment" using the field in the lower right-hand corner of your screen and submit it to all panelists. If you don't have a mic, you can type out your question. And if you're joining us by phone, you can use *3 to raise your hand. We'll give you a moment. All right, this is a moderator. I see no requests for comment. Shall I close the Q&A panel?
Yes, thank you, moderator.
Okay, it's closed.
And back to the board, there is a motion on the floor. Are there any other comments, considerations? If not, I would like for Steve to ask for a vote on the motion. Thank you, Steve.
Okay, I will take the vote on the motion. Max Disposti,
Yes.
Crystal Anthony,
Yes.
Deborah Brown,
Yes.
Ross Ehrlich,
Yes.
Susan Friedman,
Yes.
Diana Herwick,
Yes.
Christopher Jones, Jonathan Maddox,
Yes.
Kelly Ranasinghe,
Yes.
John Sovik,
Yes.
Wendy Strack,
Yes.
Christina Wong.
No.
One dissent, the rest yes. Motion passes.
Thank you, Steve. And we're moving to item 8 of our agenda, discussion and possible recommendation regarding Senate Bill 14, Portantino, pupil health, school employee and pupil training, excused absence, and youth mental and behavioral health. Roseanne, again, the floor is yours. Thank you.
Max, I'd like to request, if it's all right with you, that we skip to item, I think it's item 11 as the 801. Yeah, item 11. Just because in the interest of time, I know that you have an ALJ coming on. So we skip to that one because that one's critical. And then if we have time, circle back to the other ones. Is that all right with you?
Oh, absolutely, Roseanne. I can't love you more. Thank you so much.
Okay.
So we're moving to item just for the public, item 11, which is discussion and possible recommendation regarding Senate Bill 801, about healing arts, Board of Behavioral Sciences and licensees. Thank you, Roseanne.
Yes. Thank you, Max. So this bill is going to be the board's sunset bill. You will see you do not have any text for this bill yet. It is in print. However, the board's sunset date is, they're working on amending it in this week. And so we know what the date is going to be. They're trying to do a lot of consolidation of the bills in the legislature, and that's taking some time. So they're hoping to get it in print this week. So I don't have the print for you, but I can tell you the provisions that they're working on. To see if the board would like to take a position on those specific provisions. So what this bill currently contains and it's going to contain is first, the board's omnibus bill proposals. So we have several requests that the board has made, language that the board has approved that are minor technical or non-substantive changes. And so the board is the sponsor of these items, so no action is needed there. But there's going to be a couple of items that are going to be amended in that the board is not a sponsor of, but might wish to take a position on. And that is going to be extending the board's sunset date from January 1, 2022 until January 1, 2026. And that's going to be via Business and Professions Code 4990 and 4990.04. And then the other piece of this bill is moving the proposed provisions of AB 723, which is by Assemblymember Lowe, as introduced February 16th, 2021. And that bill was sponsored by CAMP, and it makes changes to Business and Professions Code section 4980.02 to modernize and clarify the LMFT scope of practice. And so the board has a support position on an AB 723, but that bill is going to be moving into this bill. And so the board will lose its official position on 723 when that happens. So what I'm proposing is that the board should consider taking a position on two provisions that are going to be added in that's not sponsoring. Amending sections, Business and Professions Code sections 4990 and 4990.04 to extend the sunset date until January 1, 2026. And then number two, amend the amendments to Business and Professions Code section 49.02 to modernize and clarify the LMFT scope of practice that were previously in AB 723 as introduced 2/16/21. And as long as it's the same version that the board had a support position on, when it took the position at its March 5th, 2021 meeting. So that's the proposal on the table.
I would like
Thank
to
you for
make it
that.
very,
Christina,
I would like to make it very, very fast. I think this is a no-brainer, that, we should support this bill. So I would like to make a motion to, to support this bill and also to support the two provisions, that Roseanne talked about.
I would recommend the motion be just to support the two provisions as I just read them.
Yes.
Because the bill, we're sponsoring it, and then there's going to be psychology boards, omni-bill changes and everything in there. So I would keep it to the two provisions, just because we're not familiar with psychology boards amendments.
So would you like to, read the motion again that we will be supporting?
Yes. Yes, the motion would be to support amending Business and Professions Code sections 4990 and 4990.04, which are the sections proposing to extend the board's sunset date until January 1, 2026. And then also to support the amendments to Business and Professions Code section 4980.02 to modernize and as introduced, 4980.02 to modernize and clarify the LMFT scope of practice that were previously in AB 723 as introduced 2/16/21. That the board took a support position on at its March 5th, 2021 board meeting.
Yes, that's my motion.
Okay, any seconds on the room?
I can second that, Diana.
Thank you, Diana. Okay, moderator, I would like to open to the public if there is any discussion. Thank you so much.
Thank you. So I open up the Q&A panel. If any member of the public would like to make a comment, please type "I would like to make a comment" using the field in the lower right-hand corner of your screen and submit it to all panelists. If you do not have a microphone, you may type out your question. Also, if you're listening and only by phone, you can use *3 to raise your hand. We do have a request for public comment. It's from Jennifer Alley. And Jennifer, just a reminder, you'll have 1 minute. I'll give you a 15-second warning and then move on to the next request for comment. And Jennifer, I'll let you know when you have been unmuted. And Jennifer, you've been unmuted.
Good morning, board members, and thank you for the opportunity to comment. Obviously, CAMP agrees and likes your motion to support the amendments to SB 801, and we appreciate your continued support on our efforts to modernize the scope of practice for MFT. So thank you very much.
Thank you for your comment. Moderator, do we have any other comments?
Thank you, and I'm looking to make sure we don't have any raised hands, and I do not see any, and I also do not see any further requests for public comment, and I've been instructed to let the petitioners know we are waiting for the ALJ, so just to hang in there. But at this time, would you like me to close the Q&A panel?
Yes, please. Thank you so much.
You're welcome.
Just as a reminder to my fellow board members, it's important you identify yourself as you speak, even though we can see you. A lot of people are on the phone, they can't see you. Other people are not able to see you. So just for the clarity of the conversation, make sure you always state your name every time you speak. So we have a motion on the floor and from Christina Wong. Do we have a second? I'll second the motion if there is no one.
Diana
second.
seconded already.
Oh, Diana.
Diana seconded.
And here we go. Coffee is needed. I got to that point. Diana, thank you for seconding the motion. Steve, if you would like to help us, if there are any other comments, excuse me. Any other comments on the motions on the floor? Okay. Steve, we can go to vote.
Yep.
We don't hear you, Steve.
Oops, he's gone.
Yep.
I think Steve has a connection. Okay, there you go.
Okay.
Max, would you like me to call vote instead?
Yeah, let's do that. Christina Wong, please call us for the roll.
Yeah, okay.
Oh.
So, you know, I am just going through my screen, so. Steve, I will call vote. Yeah.
Steve, your connections is really bad. We're going to move with Christina Wong calling the vote, okay? Because you're not well connected at the moment. Okay.
Yes. No. Okay.
Thank you.
Okay.
So,
Okay.
let's see.
Okay. Go ahead.
Okay, Christopher Jones,
Yes.
Crystal Anthony,
Yes.
Deborah Brown,
Yes.
John Stovak,
Yes.
Ross Ehrlich,
Yes.
Max Disposti,
Yes.
Kelly Renafengi,
Yes.
Jonathan Maddox,
Yes.
Susan Friedman,
Yes.
Wendy Streck,
Yes.
and myself, yes. Diana looks like she got kicked off. So what should we do about this one?
Diana. Okay, sorry. Diana is she just texted me. She cannot unmute herself. She's been hearing the vote. So I don't know if she's voting in favor or not, but she just texted me that she's there. She can hear it, but she can't unmute herself.
Thanks. Somebody just unmuted me, and my vote is yes.
Okay.
Wonderful.
Diana?
Thank you.
Diana Herwick is yes. Thank you. So motion carries.
Okay, at this point, Roseanne, I have a question for you. Thank you for allowing us to skip to this item. I'm a little bit concerned about the time because we have the judge waiting and our petitioners. Will that be problematic if we skip these two items for a vote?
It will not be.
Can I make a suggestion? We are. Go ahead, Roseanne.
If we don't, Steve, go ahead.
I'm sorry. We are still waiting for the judge right now, so we're trying to get in touch with them. So we might be able to do another.
If that's the case, I'd like to move to item 9, which is AB 988.
Okay, then let's move to agenda number 9, discussion and possible recommendation regarding Assembly Bill 988. Thank you, Roseanne.
So AB 988 is a mental health 988 crisis hotline. It would implement a statewide 988 mental crisis hotline system, just like we have the 911 emergency system. This would be a system where you dial 988 for a mental health crisis assistance. And so the reason for this bill is that a federal law in 2020 established what's called the National Suicide Hotline Designation Act of 2020. It designates 988 as the universal telephone number for the purpose of the National Suicide Prevention and Mental Health Crisis Hotline System operating through the National Suicide Prevention Lifeline and Veterans Crisis Line. So this bill basically is the state trying to implement the 988 system. So it defines 988 as the number designated by the FCC to connect individuals experiencing a mental health crisis with suicide prevention and mental health crisis counselors and crisis teams. It requires 988 centers to provide a person experiencing a behavioral health crisis access to a trained counselor to address their immediate needs 24 hours per day via a call beginning July 16th, 2022. And by January of 2027, the services must also be available via call, text, and chat. And then the bill to pay for itself, it charges a monthly 988 surcharge on phone service lines, similar to the existing 911 surcharge. So the author is stating in their intent that the state needs to create a framework to provide callers with care. And so this particular bill is doing that. They note that they're mandated to implement this by July 2022. And that by that time, state and counties are expected to have infrastructure in place. And they note there's no specific federal penalties for not adopting the federal legislation, but if the state doesn't get to delay the implementation, so if they don't do something, then the state's still going to have to implement the system without any federal funding or infrastructure in place. So this bill is laying the groundwork for that. And so I thought since it seems to be a pretty significant bill about mental health crisis services, that I thought that the board may wish to weigh in on this particular piece of legislation. So I'll open it up for discussion.
Thank you, Roseanne. Great call, actually. I remember we discussed this a lot because I don't mean to represent the sentiment of the board, but we were very excited to see an additional service provided in the state of California to support our mental health crisis. But question to you, one thing I was missing in reading the bill is this means like each region, let's say if I call 988 here, they will connect me with local service provider, mental health service provider, they will intervene on the scene, right? Versus 911.
Right. So there would be a separate, and there's certain criteria for how the call gets routed, but yes, it's an alternative to 911, where you aren't having to go through the 911 system, that there's somebody right there to help by calling 988.
And I think the intent of the bill, I can speak for my region here, Southern California and San Diego area, where the county has just approved mental health services interventions for those that are, when we have a homeless crisis or mental health crisis on the streets, you don't end up calling the police, which we know they are, for lack of a better word, not equipped to address these issues and de-escalating. And so it's nice to see this effort nationwide, and then hopefully every region is providing those resources where then at the end, this number is not going to end up calling 911 because in the area there are no alternative services, right? Obviously, this is not the responsibility of this bill, but it was just, a concern that I want to share, making sure that in the rest of California, they're doing the work of serving our people, not from a police standpoint of view, but from a mental health standpoint of view, so that providers can actually intervene when needed. I'm in favor of this, and I would like to make a motion, but of course, the discussion is open with the rest of the board members.
I want to say, go ahead, John.
So I would just like to, echo the sentiment. I think there's really, important that, there is a national suicide prevention hotline. There's so many other topics. So I think, when we have a national, or at least the local, the statewide, crisis work, mental health crisis line, that would be a really good central place, for people to call and then be able to, to funnel them, to the appropriate jurisdiction or the locality, of the client. So I'm also in favor and support this bill. And I can second that, but Max, if that's your motion.
Yes, thank you, Christina. Jonathan?
I have a question. So, this is a great idea. I think it's important to have a, localized, almost single point of responsibility when clients are having mental health crisis. But I guess my concern is, as a practitioner and having actually worked in several counties around the Bay Area, there are already established hotlines and protocols and processes and MOUs that are in place to support someone who's in crisis. And so I guess my question is, and this may be more so for Roseanne, I know this requires that the California HHS actually get involved and coordinate and support its implementation. Does that mean that they may make some non-substantial or substantial changes to the existing service process that currently exists, like maybe just changing the phone number or routing a 988 call to somewhere locally? Because I guess my concern is, I'm wondering what sort of disruption this is going to cause for these already created systems. And then another one is, as it's written in the bill, it talks about the 988 center being responsible for follow-up care. How does that work for people who have varying insurance needs or varying insurance realities? Like, how does all of that get worked out? I guess that's my question, because I think it's a great idea, but there's a lot of work in the weeds that needs to happen to make sure that this doesn't disrupt what already exists and is realistic based on sort of what actually happens on the ground.
Jonathan, since I made a motion, can I attempt to respond that? So actually, statistically, I know Bay Area could be a different experience that way, so I can't speak to it, but statistically, statewide, the number one responses in mental health crisis and situations where it requires intervention, unfortunately, is still rather through 911, the police shows up every single time. So that's a problem. They still exist. So the system in place, I can't speak for yours in the Bay Area, but I can see what's happening in San Diego. Until yesterday, literally, I mean, 2 months ago, there were not organizations other than PERT, which is part of the police officer as well, to intervene with mental health providers in a situation of crisis. So the idea here, again, in hearing what's happening nationwide, there is a push to take away those responses from the actual now police intervention and create a system in place. So the system in place that's here is that if you call this number, it's not just a general suicide number. This is a number that would allow us to have mental health provider coming on the scenes when something is happening, right? Of any kind. There's not violent crime, of course. So it will not disrupt in the way I've seen it. I understood this because actually it's connecting with the existing services. It's not trying to replace them, but to coordinate those efforts so that people don't end up calling 911 for anything that happens around homelessness and so forth. Of course, is it going to be perfect? I'm sure, challenges will arise, but it's an attempt to respond to these dynamics, statistical dynamics of police intervention in any aspect of mental health and poverty, as a matter of fact. So, yeah, thank you.
I was going to say, I think this isn't going in the right direction, and I would echo Max to the fullest because I do feel I'm speaking more from Southern California as well. I think San Diego has a really great system, but I think that globalizing something like what Max was saying, and then in Orange County, the same thing. I think having a global number that people can memorize, that is a 3-digit number, that is just really quick. You dial it in your phone and it's like an emergency call. It does something different. And I think it's more than protecting our consumers, it's really serving our community. Because working with underserved populations, underprivileged people, speaking from working with youth in particular who are gang involved, very few of them would call 911 in an emergency. And more of them would probably be more willing to call a mental health crisis counselor or a person to come on the scene, that they're not fearing deportation, they're not fearing arrest. It's like all of those things that make people fearful of calling for help. I think it sheds that layer down. I think this is wonderful. I think it's good that California, I think it'd be a great stance for the board to take on it too, because I think oftentimes people or states can become very reactive when a bad thing happens, but this is actually even though it's after the fact, it's thinking ahead of the time before it becomes you get penalized for not having implemented it yet. I think we're getting ahead of the curve in a sense. And we all smile because we know that a lot of our systems become very reactive. It's oh, there's a school shooting. Now we're reactive and we're going to have safety precautions. It's this is let's get ahead of that curve. And I would agree that a lot of counties do have really great systems that why reinvent wheels? But I think a lot of counties don't have good systems. And it's other counties need to catch up. And because California is so large, I think that many people can learn from other counties. San Diego's super progressive, and they've done an incredible job with their PERT team. And I know their PERT team works very differently than in other counties. And I know the Bay Area is also super progressive, but both of those counties are at the top and end of our state in a sense. So it's kind of working with those counties in between and making sure that everybody can kind of get caught up to learning how to be a good crisis counselor. And then maybe adding additional training services for our licensed practitioners that would probably be the ones responding. Just because I think my only thing is there is a level of liability with the people that are responding. And I would say what is going to be the requirements of the people that are responding? Are they going to be licensed people? Are they going to be associates? Are they going to be people that have those types of degrees, or is it just going to be people? So I guess those are some of the things that I would pose as questions as to who are the responders, because I do think having that type of support from our end, it's making sure that we can also understand where the liabilities are for our practitioners.
So thank you, Crystal. I see Susan.
Yes.
And then I see, sorry, Susan, Kelly, Ross, and John. Okay, Susan, Kelly, Ross, and John. Okay.
Okay, I just wanted to say very simply, this is just another tool in the toolbox. It certainly is not the answer. And I mean, and everything that, for example, in LA County, they have already organized it so that if a call ever comes in on 988, mental health, the Department of Mental Health sends people. Never would the police ever go. They are out of it as far as calls to 988. So, I mean, I look at this as just another tool to help with the biggest problem, which is this the suicide problem.
Thank you, Susan. You know who's next? That you raise your hands, Kelly.
So I think this is a step in the right direction, and here's why. We have to remember 80% of California is rural. And let's say you are in Salton City or Trinity or in another, one of the hundreds of unregulated counties throughout California, and you're in crisis. Are you going to look up the 9-digit phone number of your local county, which is 45 minutes away while you're in crisis, or you're just going to call 998? Additionally, for rural counties, there are cultural barriers, particularly in border communities, to calling the police when you are in a mental health crisis. There are cultural barriers in tribal communities to calling the police when you are in crisis. So calling a quick hotline which coordinates local services rather than the police is an excellent step in the right direction, particularly for those communities who may not feel safe calling the police. That's it.
Thank you, Kelly. Forgive me, I think, who was next? Russ, and then John.
Yeah, thank you. And I was wondering, I wanted to sort of follow up with one of Jonathan Maddox's points, and I don't know if Roseanne, if you know, but for those counties who do have well-established services, emergency services, mental health services, do you know what this number would do? Would that simply, if I picked up the phone and I dialed 988, would I be, based on my location, patched into one of those counties like emergency services? Would it go to a separate sort of call center? Would they then have to contact the county? I mean, do you know how that would work? Would it be sort of seamless, quote unquote?
I didn't see that spelled out exactly in the bill. I think that's sort of the goal, is that it's going to use the county resources and sort of bring those all together. But I know that in talking to the author's office, that this is, I think they know that there's work to be done, and this is kind of a first step to establish the framework. I would imagine that we would see other work on this issue, whether it be through a bill or regulations or internally with the departments involved to this more. But no, the bill, I did not see in the bill spelled out exactly how that would transfer. That may be still, it's probably still needs to be worked out.
One of the reasons, Roseanne, I'm sorry, because I've been an advocate for this for quite some time, is because each county, the state didn't want to dictate how this is going to work for each county. Each county will determine how the connection will be done. So because for the reasons that Kelly was saying, in rural situations, you have different service providers stepping in versus in a city. So I think it's just served the purpose of providing us services, and the county will have to figure out how to make it connect to it. Okay, did I miss anyone that raised their hand? Oh, John, so sorry. John.
You're just missing me today. You, Steve, everybody. Hey, so I also want to go on board as 100% support of this bill, understanding that it is the building of a scaffolding. It is the beginning of a framework, and there are going to be lots of details that I hope we as a board are going to be involved in some of the shaping of that and having input, especially from our stakeholders. I think that's a really important thing to, put into the process as well. The other thing I want to address, we're talking about like LA, San Diego, San Francisco have really good structures in place. They are also places that have very large tax bases and have access to create those services. We have a huge state where there are places that have almost a zero tax base, and they are not able to create these services. And this 988 number will hopefully kind of bring that web together in a way so that resources are being addressed through the entire state. That may be hopeful, it may be naive, but my hope is that that's what the bill and the creators of the 988 number will do. And especially for our stakeholders, I think it's really important to understand almost every therapist that I know on their office message says, and if you're facing a clinical emergency, please dial 911. In many cases, that is the absolute worst advice that we can be giving to our clients. We're encouraged by all of our organizations to put that please call 911 thing on there as a liability coverage, but it's not a good case. I've had personal experience that with clients who have been basically through really abusive situations by bringing in the 911 system. So I think by creating this secondary support system, by saying on my outgoing message, if you're facing a clinical emergency, call 988, that I will be addressing the needs of my clients on a much stronger level.
Thank you, John. Sorry for missing you. I blame my Zoom screen here. Not Zoom, you know. Anyone else? Otherwise, I would like to go to the public to get some inputs, if any, and then come back to the vote. No one else? Moderator?
All right, thank you. I have opened up the Q&A panel. If any member of the public would like to make a comment, please type "I would like to make a comment" using the field in the lower right-hand corner of the screen and submit it to all panelists. If you have no microphone, you can type out your question, and if you're participating only by phone, you can use #3 to raise your hand. We do have a Jennifer Alley that would like to make a comment. So again, Jennifer, you'll have 1 minute. I'll give you a 15-second warning. And Jennifer, you've been unmuted.
Good morning again. This is Jennifer Alley with the California Association of Marriage and Family Therapists. We do have a support position of this bill, and we think it's a good direction to go for public safety and for those in crisis. Thank you.
Thank you, Roseanne. Anyone else?
This is the moderator, and I see no other requests for public comment and no other raised hands. Would you like me to close the Q&A panel?
Yes, thank you.
You're welcome.
Okay, at this point, I will, unless there are any other additional comments, I would like to ask Steve to call for the vote.
Okay. Okay, I think I have a good signal now. So can I get who had the second on that, please?
It's me, Christina.
I'm sorry, was the motion
thank
to
you,
support?
Christina.
Was the motion to support the bill?
Yes, I did. Yeah, a motion
Okay.
to support the bill. Yeah.
Okay, so if the motion to support the bill, I'll take the vote now. Max Despostny?
Yes.
Crystal Anthony?
Yes.
Deborah Brown?
Yes.
You? Ross Ehrlich?
Yes.
Thank you. Susan Friedman?
Yes.
Diana Herwick?
Yes.
Christopher Jones?
Yes.
Jonathan Maddox?
Yes.
Thank you. Kelly Renafini?
Yes.
You? John Sobek?
Yes.
You? Wendy Streck?
Yes.
You? And Christina Wong.
Yes.
Thank you.
Thank you. Thank you, Steve. Motion carries. So at this point, Roseanne, I believe the judge is in the room. So it's they are arrived. I would like to skip the other two items, if it's okay with everyone, and take a 10 minutes break. We are reconvening at 10:55 so that we can start our petition part of the board today. Is that okay? So 10:55, we reconvene here live. Thank you so much. The Board of Behavioral Sciences, resuming our work for today. My name is Max Disposti. I'm the board chair, pronounced him as. Today is Wednesday, July 7th, and the time is 10:56. At this moment, we will begin our work with our petitioners, and our Judge Bennett, if I'm correct, will take over the portion of this meeting
Get on. This is
now.
Rachel. I need to speak to you. The board's attorney.
And please, if you can mute if you are not speaking because we have feedback from someone else. Thank you so much. Thank you, Your Honor. Thank you for being here today.
Hello?
We can hear you.
Just a second. Mr. Moderator, it appears that Patricia Heim is not on. She was unable to get on, the Deputy Attorney General.
This is the moderator. She was logged in and we did a mic check, so perhaps.
I just got a
I'm here.
phone call. Oh, she's here now. Okay, great. Yeah, she's on now. Thank you. Okay, bye now. Okay, she is on now. I got a call that she was not on, but okay. Okay, please proceed, Mr. Chair.
I was just introducing you to the public and knowing that from now on you'll take on the proceeding of this meeting by reviewing hearing our petitioners. I believe Your Honor, your last name is Bennett. Am I correct?
Bennett, that is correct. B-E-N-N-E-T-T. First name Wilbert, W-I-L-B-E-R-T. Okay,
thank you, Your Honor. It's a pleasure to meet you, and now the floor is yours.
Thank you, Mr. Chair. First of all, it looks like our first matter here is the petition for termination of probation of Amber McKinney Morgan. Is that correct? And I just want to make sure that she is on.
I am here, sir.
Oh, okay, thank you very much. Okay, let me say a few brief preliminary things, and we will be proceeding. First of all, we are here today to review the petition for termination of probation of Amber McKinney Morgan. Will all of the board members please identify themselves for the record?
Yes, Your Honor. Perhaps we can do, Steve, would you mind to call our names so it will be easier so we don't overlap each other? Thank you,
that's
Steve.
an excellent idea. And correct me if I get the pronunciation wrong. Max DePosti? Is that
correct? Yes, Your Honor. I'm a public
Okay.
member and chair.
Public member.
Yes.
Okay.
Do you want me to start then?
Yes, Steve. Thank you.
Okay.
Christina Wong.
And actually,
yes.
Your Honor, we'll have our staff doing that for you. So because you know, they know exactly who they are online, and we can go much quicker if you don't mind. So
Okay,
Steve,
that would be fine.
Perfect. Thank you.
Perfect. Okay.
That would be fine. I just wanted to make sure that we do have a quorum.
Wonderful.
Okay.
Yes.
So we have Max Disposti, you said here. Christina Wong.
Here.
Deborah Brown.
Public member.
Yep, great. Ross Ehrlich.
Here, public member.
Thank you. Susan Friedman.
Here, public member.
Thank you. Diana Herwick.
Here, LPC member.
Thank you. Christopher Jones.
Here, LEP member.
Thank you. Jonathan Maddox.
Here, MFT member.
Thank you. Kelly Ranasinghe.
Here, public member.
You, public member. Great. John Sovek.
Here, LMFT member, pronouns he, him.
Thank you. Wendy Strack.
Here, public member.
Thank you. Absent, Yvette Willis, and Crystal Anthony actually had to leave, so we have a quorum.
Thank you, Steve. Your Honor, it's now your turn.
Okay. Thank you very much, Mr. DePosti. Okay. As I was saying, we're here today in this proceeding to review the petition for termination of probation of Amber McKinney Morgan. First of all, again, my name is Wilbert Bennett. I am an administrative law judge with the Office of Administrative Hearings assigned to preside over this matter. And before I proceed, I just want to take a few brief minutes. First of all, as the record reflects, because of the ongoing health crisis, we are proceeding virtually on this matter. This matter that is before us bears Office of Administrative Hearings case number 2021-060-293 and Board of Behavioral Sciences case number 2002-018-002605. May I take the appearance of the Deputy Attorney General? Ms. Hine? Is Ms.
Good morning,
Hine?
Patricia. Can you hear me?
I can hear you. Oh, yes. Thank you very
Okay.
much. I can see you now. Okay. Patricia Hine.
Thank you. Patricia Hine,
Okay.
appearing on behalf of the people of the state of California pursuant to Government Code Section 11522.
Thank you. And Ms. McKinney Morgan, you are present.
Correct, Your Honor.
Okay. And you are representing yourself, is that correct?
My attorney, Miranda McCroskey, should be here.
Okay, is Miranda McCroskey present?
This is the moderator, yes, and I have made her a panelist.
She is present. Okay, you're confirming her presence, is that correct?
That's correct.
Okay, very good. Very good.
Your Honor, can you hear
Yes.
me?
Yes, I can hear you.
Yes. Oh, great. This
Yes,
is
I can
attorney.
hear you.
This is attorney Miranda McCroskey. I only was just given audio just now, so I am going to start my video and there. Okay. Thank you, Your Honor.
Okay, thank you. Thank you. Okay. Okay. Are we ready to proceed? Are we ready to proceed? Okay.
Yes, Your Honor.
I would ask the. Yes. 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 Yes.
Your Honor.
Mr. Posey?
There is an echo coming from you, I believe, because you have two open line of communication. I don't know if you're using your phone and computer.
My phone is off. And I'm not on the phone. Is there? I'm hearing an echo.
Right.
Sometimes that has to do with the volume too. Sometimes if you have your volume all the way up, it might cause that.
Okay. Can everyone hear me?
Yes, we can hear it very well. Yeah.
Okay, there was an echo just a minute ago.
Right. I think it's gone now. Thank you.
Oh, okay. And please, if anyone cannot hear the proceedings, notify someone so we can take appropriate corrective action. I just confirmed the presence of Ms. McKinney Morgan's attorney. And at this point, I was going to mention to the court reporter if she could please notify us when this matter is proceeding, when this matter is terminated, and tell us how many estimated pages of hearing time have taken place, and so that the parties have information about if they should want to order a transcript. So at this point, I am going to George, just briefly, in just a few minutes, turn this over to the Deputy Attorney General. And in this proceeding, for the benefit of the petitioner and her attorney, in this proceeding, the board is concerned with hearing about any rehabilitation since your license was disciplined, Ms. McKinney Morgan. The Deputy Attorney General will first present a petition package and provide background or a case summary in this matter. And after that, you will have an opportunity to make your presentation. Remember that the board has had the benefit of reading the petition package, and you do not have to repeat anything in that package. You will be subject to questioning by both the board members and the Deputy Attorney General. After the hearing, the board will go into closed session to deliberate, and you will not receive a decision today. It will be mailed in the near future. And usually, most boards will defer the closed session until the end of all of the matters today. So that just gives you kind of a brief thumbnail sketch of how we'll be proceeding today. Do you have any questions?
No, I
Ms.
don't, Your
McKinney
Honor.
Morgan, any questions?
No, I don't, Your Honor.
Okay. At this point, I will turn the matter over to the Deputy Attorney General to proceed. Ms. Hine, please proceed.
Can you hear me?
Yes.
Thank you. I will first begin by reading the disciplinary history and the probation compliance history, and then I will introduce the exhibits that have been marked and presented both to the Office of Administrative Hearings as well as the board members. Petitioner was issued an Associate Clinical Social Worker registration on or about June 5th, 2019. On May 27th, 2015, Ms. McKinney Morgan was convicted of a misdemeanor DUI. A statement of issues was filed on August 7th, 2018, and the board adopted the stipulated settlement and disciplinary order, which immediately revoked, stayed, and placed the petitioner on probation for 3 years with optional and standard terms and conditions, effective June 5th, 2019. There is no history of tolling in this matter. Ms. McKinney Morgan completed her psychological evaluation and no DSM-5 diagnosis was found. Her biological fluid testing was reduced to a minimum of 24 times per year. Petitioner is requesting early termination of probation and is represented by an attorney. Regarding her psychological evaluation, this was completed on September 12th, 2019, and she was deemed safe to practice with no recommendations. Regarding her psychotherapy quarterly reports, she is fully compliant. Regarding the dependency support program, she is fully compliant. Regarding the remedial education requirement, she completed this on January 21st, 2020. She is fully compliant with the biological fluid testing component, and she is fully compliant with the standard terms and conditions, including quarterly reports and reimbursement of costs. And now I will introduce the petition packet. Pre-marked as Exhibit 1 is the original petition for reinstatement packet with the accompanying documents. The petition for early termination of probation is dated October 7th, 2021, and includes the following attachments. A letter dated September 24, 2019, confirming completion of the service obligation for the California Social Work Education Center Mental Health Services Act stipend. There is a Community Research Foundation performance evaluation, which in the marked package includes pages 5 and pages 8 and 9 in the Exhibit 1. Petitioner's typewritten letter of explanation, which supplements her petition. This is followed by the San Diego Youth Services 3-month progress evaluation dated November 14th, 2018, and the annual performance evaluation dated May 28th, 2020. There is a Dexcom 2016 mid-year review form, followed by the City of San Diego Parks and Recreation Memorandum dated August 4th, 2015, with a bi-weekly staff feedback form dated June 30th, 2015, a performance review dated July 23rd, 2015, and a bi-weekly staff feedback form dated October 21st, 2014. There are letters of reference, including a letter dated February 23rd, 2019, from Gina Pollock, ASW, a letter dated May 27th, 2020, from Gabriella Vilchis Marshall, excuse me if I mispronounce names, a letter dated May 26th, 2020, from Chelsea Farrar, the AA sponsor, a letter dated October 23rd, 2018, from Deborah Asper, LMFT, a letter dated May 28th, 2020, from Wendy Wheel, PharmD, Professor of Behavioral Sciences, Alcohol and Other Drug Studies Director, Alcohol and Other Drug Programs and Co-Chair, Department of Behavioral Sciences at San Diego City College. And this is followed by a letter from Natalie J. Medina, medical doctor. The November 6, 2018 request to set the accusation matter for hearing with the notice of hearing dated, served November 8, 2018, followed by court documents from the San Diego County Superior Court, case number M as in Mary, 199761, which includes the Mothers Against Drunk Driving Victim Impact Panel receipt of attendance filed July 20th, 2015, the Certificate of Completion of the Court-Ordered DUI Program, dated October 1st, 2015, the verification of ignition interlock installation, dated June 23rd, 2015, the Certificate of Completion of the Court-Ordered 9 Days of Public Service, dated July 17th, 2015, and the receipt for payment of fines and fees, dated September 15th, 2018. And finally, there are 5 pages of continuing education certificates of completion. At this time, I would like to submit Exhibit 1 for all purposes.
Okay. Any objection? Okay, Exhibit 1 will be admitted into evidence. Okay, please proceed.
Thank you. Pre-marked as Exhibit 2 is the stipulated settlement and disciplinary order, which was effective June 5th of 2019, which ordered that petitioner's associate clinical social work application, is granted, then immediately revoked, stayed, and placed on 3 years probation with terms and conditions. Included in this is the Statement of Issues number 200-2018-002605, dated August 7th, 2018. At this time, I would like to submit Exhibit 2 for all purposes.
Any objection? Okay, Exhibit 2 will be admitted into evidence. Please proceed.
Thank you. And finally, pre-marked as Exhibit 3 is the notice of hearing to the petitioner dated June 7th, 2021, and the registration and license history certification for petitioner for the Associate Clinical Social Worker Registration Number ASW 89316, which is in full force and effect and will expire on June 30th, 2022, unless renewed. At this time, I would move to submit Exhibit 3 for all purposes.
Any objection? Okay, Exhibit 3 will be admitted into evidence.
Thank you. And because the burden is on Ms. McKinney Morgan to show that early termination of her probation is warranted, I reserve the right to question her until after her statement. Thank you.
Okay, thank you. Ms. Heim, I have one question, and maybe this is going to be clarified shortly. It appears that Ms. McKinney Morgan submitted documents about a year earlier, and I'm not sure if those documents are part of this proceeding. There were documents, many of which were prepared by Attorney McCloskey, and she might be able to speak to that. Some of these documents are not in the Exhibit 1 that you submitted. And perhaps she wishes to speak to these other documents that are part of the file. Is your attorney present?
I'm present, Your Honor. Thank you.
Yes, Ms. McCloskey.
This has been a long, Your Honor, this has been a long, drawn-out process, and I have represented Ms. McKinney Morgan through the statement of issues and all the way to present. So I'm trying to remember which documents you might be referencing. We generally create a mitigation packet with a cover letter and rehabilitation evidence. However, the rehabilitation evidence I see in regard to the petition for early termination, my assumption is they're duplicative of the mitigation packet. Could you clarify what documents you're referencing?
Well, there are documents that were part of your letter to the board dated June 27, 2020 that have attachments A through K, it appears. And perhaps you've elected not to proceed with that, but they were submitted about a year ago, and maybe they're not part of this current package. Was it your intention that these be part of this proceeding?
I'm trying to walk through the history of it in my head as we speak. We did originally, about a year ago, we did intend to petition for not early termination, but modification. And then we chose not to because of a lag in COVID and not being able to get a hearing. So I'm not giving you a direct answer, Your Honor, because I'm trying to pull up the documents as I'm speaking so I can see. Can Your Honor tell if it's duplicative to the petition you're currently, that's been offered in evidence?
You know what, counsel, I didn't look at each and every single document. It appears that some of them were duplicative. It appears to be your intention. There's actually a letter from Ms. McKinney Morgan that says that I'd like to make a modification. This letter is dated June 7, 2021. It says I'd like to make a modification in my petition request. While originally requesting for a modification 1 year ago, I since decided to wait a year to petition for early termination. So I'm going to assume since you're not prepared to proceed with these other sets of documents, that they are duplicative. And I do not believe that they were presented to the board members, although I could be wrong. If the board members received only the packet of material that was included with exhibits 1 through 3, then perhaps this shouldn't even be a part of this proceeding. So, Ms. McCroskey, I will proceed on that basis then, that these, whatever was submitted earlier, are simply duplicative of what is before the board currently. Okay, that's how we'll proceed. Agreed?
Agreed. Oh, sorry, I was muted. I apologize. I think that's a safe assessment, Your Honor. Go ahead.
Okay, so these matters are not before the board. The other matters that I was referencing earlier are not before the board and will not be a part of this.
That's correct. We're doing the petition for early termination with the attachments the DAG has offered into evidence.
Thank you, and I just wanted to clarify.
that.
Okay, thank you. And I apologize if you're hearing an echo. I'm not sure what to do about it.
This is the moderator. The echo is from the representing lawyer leaving her mic unmuted. So a microphone should only be unmuted if you're speaking.
Okay. And can everyone hear me okay? I just want to make sure. Okay. Okay, the exhibits 1 through 3 are in evidence. At this time, it is time for the petitioner's presentation. Ms. McCroskey, do you wish to make a brief opening statement? Or shall we?
Yes, Your Honor.
Okay.
Briefly, Your Honor, I simply want to reiterate what the DAG stated as far as my client's complete compliance with all aspects of termination for the last 2 years, and also remind the court that this began because a statement of issues was filed, which was based on the underlying criminal conviction for a misdemeanor DUI 6 years ago. And in the intervening 6 years, well, frankly, prior to the DUI and in the intervening 6 years, there's been no issues of any criminal conduct, no issues of substance abuse whatsoever. And that paired with my client's compliance with the psychiatric examination dependency program, remedial education, and drug test, we believe are strong indicia that she should be released from early probation. And then she will tell you more about the rehabilitative actions that she's taken in the last few years.
Ms. McKinney Morgan, this is your opportunity. Again, I mentioned earlier that this hearing is concerned about rehabilitation since your license was disciplined. And so this is your opportunity to make your presentation to the board regarding rehabilitation and any matters that you think are germane to the board's decision on your petition for reinstatement. Again, the procedure is that you make whatever statement, present anything that you wish to in terms of your testimony, and then you would be open up to questioning by the Attorney General and by the board members directly. So please proceed, but before you proceed, I do want to swear you in as a witness. So if you would please, do you swear or affirm under penalty of perjury that your testimony in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Okay, Ms. McKinney Morgan, please proceed in however manner you see fit.
Good morning, Your Honor. Thank you for giving me this opportunity to speak. I know you did mention that, I did submit a statement of rehabilitation to not reiterate that, so I will try not to do that. I have been compliant with the BBS requirements, and that includes the psychotherapy, the AA meetings, the biological fluid testing, and more, the substance use college level course. And on top of those things, I have also taken upon myself to engage in trainings around substance use. So I've been trained in seeking safety therapy. I've also considered taking the pharmacology course from Dr. Wendy Wheel, who's in the evidence, the pharmacology teacher. I, deal with life stressors by going to wellness collectives, so sound bath, yoga. I have a treadmill now, so I'm running. I like to read self-development books. I am around a supportive group of people that support, me and my efforts and my requirements. I continue to excel at work. Actually yesterday, my director came to me and offered to write a letter of recommendation. Yeah, outside of the BBS compliance things, those are the efforts that I've been taking to prove my rehabilitation in addition to the requirements. I've had a passion for this field, and it means a lot to me, and I understand why I've had to go through the requirements that were put upon me. And I think that I've gained a lot of insight from that, and additional education that I can take into my practice around substance use, pharmacology, things like that.
Okay, Ms. McKinney-Morgan, anything further?
Not that I can think of, Your Honor.
Okay, at this point, I would ask if Ms. Heim would like to proceed with questions. Ms. Heim?
Yes, thank you. This is Dag Heim. Ms. McKinney-Morgan, I will ask a question and then I will mute myself and wait for your answer. So it may take a little bit of lag time. My first question is, so what I've heard you and both your attorneys say is that in the intervening 6 years since you were placed on probation, there have been no other criminal convictions. Is that a correct statement?
That is correct.
Thank you. So is it a correct statement then to say there are no other criminal or civil charges pending against you in this state or any other jurisdiction?
That is correct.
Thank you. So can you please tell me what factors you believe led to your discipline?
Well, I understand that the Board of Behavioral Sciences has a business and professional codes, I hope I didn't butcher it, to adhere to. And that I did have a misdemeanor DUI from 2015, and that the Board of Behavioral Sciences took action to ensure that the safety of the public that they serve. So I understand that had to happen.
Thank you. And what do you think you have learned during your probationary period that will assist you in not repeating the conduct that led to the statement of issues?
I feel like I've gained insight to why the board operates the way it does. It takes the actions that it takes. I've gained additional insight into substance use through the college courses that I was taking. I've had a lot of takeaways and insights, and I'm appreciative of the requirements in that way.
Thank you. And can you tell me what assurances you can offer the panel that any similar conduct would not be repeated?
Yes, I've been compliant for the 2 years that I've been on BBS probation. And additionally, I've taken steps outside of my requirements to ensure rehabilitation, to assure you all and and that does include engaging in wellness activities, running, self-development books, taking additional courses. Also, at times, arranging for, my therapy requirements have been reduced. And while they have been reduced, I do set up additional sessions as needed if like a quarterly report is due at my job, or I'm needing to deal with the life stressors. I do not just do the bare minimum of the BBS requirements.
Thank you. And you mentioned therapy. So that was a requirement of your probation. If your probation is terminated early, do you intend to continue with therapy as needed?
Correct. I will continue as needed, and as some of the quarterlies would reflect, I'm right now only required to do once a month, and I have made additional arrangements as at times when needed. And so I've been in therapy prior to BBS probation as needed, and after, I plan to do so after as well.
Thank you. When I was reviewing your typewritten explanation, I didn't notice a specific sobriety date. Do you happen to have a specific sobriety date?
Correct. As far as sobriety, from June 1st, 2018.
Thank you. And so at this time, is it a correct statement that you are not drinking alcohol?
That is correct.
And if your probation is terminated early, do you have any intention of resuming any consumption of alcohol?
No, I think, in all honesty, since my sobriety, I've, peer influences or events like celebrations or things like that, they don't need to include those things, that you can have a good time without relying on those things. And I think that that's a big insight that I've had. So yeah, I'm appreciative of that.
Thank you. And you have mentioned various things like wellness and running and taking self-help courses. Do you have a specific plan for when you encounter stressors in your life in addition to those things?
In addition to those items, you're asking in addition to the items that I've listed already? Okay. Yeah, so I do have in addition to the wellness, I do have a support system in place, and that includes my little sister. I'm really close to her. It includes my partner, my pets, and even the work environment that I'm in. Everybody is very supportive. So there are the social supports in place. I put together kind of like a self-care pack for the moments that are really stressful that I go to, and it includes like cute YouTube videos of kittens and things like that. So I think the books, the yoga nidra, the breath work, exercising, in addition to the social supports and, the funny things that I can reflect on in life, it definitely helps.
Thank you. So is your lifestyle dependent on the income that you earn with your associate registration and if you were to become fully licensed?
Correct.
Thank you.
Would you like me to say? Sorry.
No, no. Can you talk about if there's any specific reason that you would like to talk to the board about why you want your probation terminated early?
Yes, a big factor is that it is a huge financial strain. I recall first talking to my first probation monitor, and wanting to go through with the process and not knowing how I would afford it. And in that time, I took up second jobs or side jobs to make money to be able to afford it, because I am very passionate about pursuing this this profession. It's something I've known I wanted to do since I was 13 years old, and it's kind of surreal that I'm even having the opportunity and the privilege to practice. But my lifestyle is dependent upon the income that I make. And I feel like with the position that I'm in right now, while I love it, it is a community-based mental health program. I don't make the most, and but I feel like at the same time, their understanding of my probationary status and flexible with me if I need to take some time to go test, if there's no options available before or after work. So things like that I'd like to be able to maneuver more freely with. So financial wise and time constraint wise for some of the items.
Thank you for your information. And at this time, I have no further questions.
Okay, thank you, Ms. Hine. I'd like to ask just a clarifying question. You are currently an associate clinical social worker, is that correct? So,
Your Honor.
okay, you mentioned that if you were off probation early, it would alleviate financial strain. So if you were terminated if you were terminated from probation early, would you seek other employment?
I think I would be, yeah, I think that I would consider that, but also I recently completed my hours for licensure, and I do have an interest. You know, the vision that I had when I was 13 was to have a private practice, and I'd like to have the opportunity to pursue that as well.
So the financial strain that you're talking about is simply that your income isn't as substantial as you would like it to be. Is that correct?
Your Honor, that is a piece of it, and the other piece of it is that, you know, I have some months where I have to pay $400 in biological fluid testings on top of the $100 probationary fees on top of other things. So that has been a strain in that way as well. The psychological evaluation, I believe, was $3,000 or $4,000. So there have been financial strains in that regard as well, Your Honor.
So it's a mixture of perhaps biological fluid testing costs, probation costs, plus lower income because you're on probation. Is that correct?
Correct. And Your Honor, I'm a first generation college student, so I don't have the financial backing that my family would like to provide.
Okay, thank you. I just wanted to clarify those matters. Do the board members have questions?
Your
Please
Honor,
identify yourself for the record.
Your Honor, Board Chair Max Disposti here. Just for the sake of procedures, if you don't mind, if I may suggest, usually what we do, we just go from, if we were in person, we'll go from left to right or right to left to see if everyone met. So we can have you calling each one of us, or the staff member doing so to make sure so that we don't overlap voices and so forth.
That's right. That's an excellent idea. Please proceed on that basis.
Thank you. We have been there before, so that's why.
Okay.
So Steve, if you don't mind, can I ask you to call our names? I can start myself, but are you there to follow through?
Yes, I can do that. And what I'll do is I'll do one way this time, and then on the next one go backwards. So
great. That's really great. So I start at this point, right?
Yes.
Thank you, Steve.
Sure.
Hi, McKinney Morgan. Hi, it's good to see you. Thank you so much for coming. I know it takes a lot of work just to get here and share your story with us and with the public. So the board is always very commends the effort of people coming forward and sharing their story with us. So thank you for doing that today. My only questions, I think you've been very self-explanatory about the journey and everything else. Can you just elaborate a little bit more about, obviously, you know, ever since this has happened, you share with us how your recovery process has been helpful, even the things that we put in place to guard you from this happening again. Can you tell us a little bit more about the conversation, the journey that you experienced in understanding? Obviously, that what happened, it was wrong. You already shared that, but a little bit more about the work you've done inside, and so that we can feel a little bit more comfortable about this. Thank you so much again.
Thank you for having me, and good morning to you too. Yeah, I've had a lot of insights, and I also journal about them. I wish I had my journal right next to me, but I feel like I've, with regards to like AA meetings, there can be a stigma, and I think, having gone to, 3 meetings a week and sometimes 5 meetings a week, like I've really developed bonds with those individuals, that I know that there's like a supportive community that is also, centered in sobriety. So I have insights around that. I have insights around just a general knowledge of, substance use and how it impacts the body psychologically, physiologically. And that comes from the college course that I took. Really developed, I was able to bring in my lens of clinical social work into that, the AOD field, and really have some meaningful conversations in the classroom and with the professor. And so we've kind of developed a connection where I'm interested in taking the pharmacology course to further my knowledge there. Really having insights around, and I'm processing this with my therapist around, what looks like a huge mountain and feels like it can't be accomplished, like all of the requirements starting out, and the financial constraints and the time constraints. Really just starting with that first step and working through it as you go can be accomplished, and can be done, and having the supports and the insights of, what supports me and gets me through that, with my therapist, having those types of conversations, really having, I feel like really having learned like that the BBS is, their intention is not to make it harder on me, but to protect the well-being of the public. And that was a huge insight for me. So I really respect and understand that now. And I think what started out as like this big nervousness and feeling like it was punitive towards me is now like, no, this is like an opportunity. It's a privilege to practice right now. And I really understand, I feel, why the BBS proceeded how they did, and that wasn't anything specifically to me, but in general, this is how these are the safeguards they put in place to serve the public.
Thank you for that. And look, and in reason of that, the reason why I was asking also, so what are the coping mechanisms? Because, fortunately and thankfully, we're here, right? You made a decision at that time that could have jeopardized your lives and the lives of others, right, on driving. So I'm so glad that we're having this conversation because no one was hurt. But at the same time, why that decision was made? Have you had worked on that in relations? I don't need a therapeutical, experience. I'm not even a clinician, but more about understanding why, how you got to that decision and what you put in place in case the stress and the overwhelming, life all around us can put those pressure on us, and how you'll be preventing from this happening again.
Yeah, definitely. I think, and just to clarify, you're referencing how I got to the decision to drink and drive?
Yeah, pretty much,
Yeah.
yeah. Thank you for asking clarification.
No problem. Yeah, I think, at the time, I'm an individual with lived experience, a history of lived experience, and I think that I didn't have the insight and awareness at the time of the full, coping with life stressors in the best way. I made a poor decision, and I was, I've learned from it. I was humiliated by it. I also was very pained that, realizing that I was putting others' lives in danger, including myself and others, and it impacts families, and it has a ripple effect. I think a lot of psychoeducation throughout the process. I actually have been electing on my own outside of the BBS probation to see therapists and gain insight and get psychoeducation since that's happened, which one of the letters in the exhibit is from the therapist that I saw when that incident happened. psychoeducation, reading self-help books around adult children of alcoholics, around substance use in general, has really given me the insight of that. And I fully understand the seriousness of the decision that I made at that time. I've since put other coping mechanisms in place so that doesn't happen again.
Thank you so much that answered my question. Your Honor, I don't have any further questions, so perhaps Steve can help us to move along the next board member. Thank you again. Thank you for being here. Steve?
Yes. Deborah Brown, any questions?
Good morning. Thank you for being here. I have only one question, and that is, after all you've experienced, is there any one thing that you believe that you would continue on with as a result of your probation?
That's a good one. I think I have multiple, therapy being one of them, but just the community that I have with some of the AA members, I really appreciate that. And I know you mentioned one, but the third one would be I am interested in taking that pharmacology course when time permits in the future. So
Thank you very much.
thank you.
And Ross Ehrlich.
Good morning. I don't actually have any questions for you. I just wanted to thank you for your time, for your candor and testimony today, and also to congratulate you on your work anniversary for doing important work with at-risk and homeless youth. So appreciate it. Thank you again for testimony today.
Thank you.
Great. Susan Friedman.
Hi, I don't really have any questions either, but I do want to thank you for being here and sharing your journey, which really looks like you had a very impressive journey. And I appreciate all of the insights that you gained, and you're sharing those insights with us. Thank you.
Thank you.
Diana Hurwitz. Diana. I'll move on and come back. Christopher Jones.
Hi, thank you for being here. I only have one question, and please forgive me if I get this incorrect. I'm trying to take notes, and I may not have written everything down. You indicated that your sobriety date was 2019, June 1st?
June 1st, 2018.
2018. And this incident occurred in 2015?
Correct.
Why is there such a big gap between the incident and the sobriety date?
There is a big gap. Thanks for calling that out. I think at the time I was learning that, you know, people's places and things, right? I had friends, I had friendships and communities that I was connected to at the time. And there's a relationship and bonds there, but I also think that I learned about relationships that are respectful of your boundaries and vice versa, even though that they're different. And I think it took some time to sever those ties to those individuals and those communities.
Thank you.
You're welcome. Thank you.
Hey, Jonathan Maddox.
Good morning, and thank you for coming. And it's been great to see the progress you've made since this incident in 2015. And thank you for your work. I just have a couple of questions. One of them is a curiosity, and then the other is something else. How do you potentially describe your relationship to alcohol if you were to get off probation? That's how would you describe or relate to?
I think that there isn't one that exists at this point. I've worked through the steps. I have acknowledged and done some deep reflection on where I was in 2015, how that impacts other people, how that impacts myself, where that came from, and it doesn't exist right now. Like the community and the people that I associate with, they're very respectful of me and my wishes, and I can go out, and if somebody's having a a birthday celebration at a restaurant or a brewery or even a bar, like I have my go-to. I'll drink ginger beer or Red Bull or something like that, and I can exist and celebrate my friends and not have, it doesn't mean I have to be on the same page as them. I think also with my sobriety can also see for people who do drink how it might impact them, and it only reinforces my stance on where my relationship is with alcohol today.
No, that's fantastic. It sounds like you really have some great coping skills. You've set boundaries for yourselves and don't see that as a potential part of your life because it's not now. So thank you. The other question I had was when board chair Disposti asked you about insights you've learned, you really talked about a lot of things that were external, what you learned about the board, what you learned in school, things you may understand as a therapist, but you didn't really speak much about internal insights like what was going on for you at the time or what you have learned like through therapy that will support your not making that choice again. So could you speak to that? Could you speak to some of the internal insights? Because those are actually more important than just what you know, because what we all know can fail us. But when we understand who we are and why we make certain choices, then that has the potential to be much more of a meaningful change. So I'm curious about that.
Yeah, definitely. Thank you for that. I think that the insights around, I would say maybe generational trauma or generational impacts of like growing up in an environment where, mental health was a stigma. And I was the person that saw the, symptoms in others or saw things, homelessness in my community, things going on around me. But not really putting a name to it or connecting it with getting mental health support or identifying healthy coping mechanisms. I think through the process of therapy, through the psychoeducation, through reading self-help books, I've become more self-aware in that sense of, if, the environment that I grew up in, including like housing instability myself as a child with my family, is impacting me in present day, how to put a name to maybe the symptoms and who to reach out to, community supports, whether it's support groups or therapy, wellness collectives, yoga, things like that, to really identify the symptoms within myself and engage with the appropriate supports to alleviate the life stressors. That was a big insight for me.
Oh, thank you. I really appreciate that. And thank you again for coming today.
Thank you.
Okay, Kelly Runasinghe.
I have no questions.
Okay, John Stovik.
I also want to thank you for coming today with your honesty and integrity. I know this is going to be a challenging situation, and I have no questions at this time.
Thank you.
Okay, Wendy Strack.
Just thank you for being here, and I don't have any questions as well.
Okay, Christina Wan.
Hi, thank you so much for being here, Ms. McKinney Morgan. So just a very quick question. I know that our board members, have, asked different aspects and, about your recovery and stuff. So my question is that, can you tell us briefly, why did you drink, or the role of alcohol in your life previously? What is that for?
Thank you. Previously, why I drank, I think that I did not have insight into my own, impacts of my symptoms, growing up with housing instability in my childhood and navigating young adulthood on my own. I think I didn't have insights in that, and I did make a poor decision to drink, and it had a huge impact on me and a huge impact on others. And that was the place I was at then. I did not have insights and awareness around myself. I did not have insights and awareness around, the decision to drink and drive. And I have that now, and I have that even more so having gone through this process as well.
So apart from that awareness of, the consequences, how about, for you, what really, what did alcohol do for you, at that time? Now you gain insight. So what did alcohol do for you?
I think at the time, I think I would have said that it helped me relax. It helped, the symptoms that I was experiencing relax a little bit, which isn't true, right? It's a depressant. It kind of makes things worse. So.
Well, and that's exactly what what I'm trying to, tease out is, I think that is important that, you recognize, and also, have the, courage to really recognize, what the role of alcohol in your life, because, otherwise I think the chance for relapse, is pretty high, and I think, Mr. Jones asked about, that 3 years you were continuing to use, so to me, it's like you have like 2 years clean, but then, within that 3 years, you were still using even after, the criminal conviction. And so, so I think this is important for us to really look at is like, why would be different this time? So thank you so much. That's all I have.
Do you mind if I comment a little bit?
And
Oh, Mr. McKinney Morgan wants to say yes. Go ahead.
Sorry about that. I will add in there that that it is a good acknowledgement that you're making within the 3-year gaps that both of you made. Within that time frame, outside of like, learning about people that are supportive of you, like people that really value your wishes in life. I was also in therapy. One of the therapists wrote a letter, and that letter's in the exhibit. Through that time, I was able to address the previous, like, generational and, housing instability experiences and how they impacted me through the use of EMDR with that therapist as well. And I'm now, it's kind of come full circle. I'm now trained in EMDR, so it's amazing.
Thank you so much. That's good information. Thank you.
Thank you.
great. And I was just going to circle around with Diana once more if you had any questions.
No questions. I just wanted to thank you for coming and sharing your story with us.
Thank you.
Excellent. That is everyone.
Thank you, Steve.
Thank you, Steve.
Your Honor, back to you. I know you had to make some final proceeding before we take a break, and I would like to interview my fellow board members if we would like to go to lunch or take a smaller break and things like that. So I'll leave it up to you at the moment to finish this.
Okay.
Thank you, Your
Thank
Honor.
you, Mr. DePoste. Have all the board members asked the questions that they wanted to ask?
Yes.
Anybody, Deputy Attorney General, any further questions? Ms. Heim, do you have any further questions?
No, I do not. Thank you for asking.
Okay, does your counsel have any questions?
Yes, Your Honor. I have 5 brief questions. 2 are points of clarification. Sorry if they're petty. I just want to make it clear. Amber, you mentioned ginger beer. That's non-alcoholic, correct?
Correct. It's non-alcoholic.
I didn't want that lingering. Also, Board Member Wong said, and I'm not calling you out, but said something around, oh, so you may have been sober for 2 years. By my calculation, it would be 3 if we use the June 1 of 2018 date. So just wanted to clarify that. The last 3 are clarifications around your criminal probation, not your BBS probation. So 1, were you compliant with your criminal probation?
Correct.
2, did you have to complete your full term of probation?
No, it was ended early.
Similar to this with a motion for early termination? Yes.
Correct.
And 3, have you had your criminal conviction expunged?
Yes, that was expunged early as well.
Okay. That's all, Your Honor. Do I have a few minutes to just say a few closing words?
Yes, Mr. DePoste, is that convenient? If the parties have a few minutes for closing?
Yes, usually the judge offers the opportunity for closing statement. Yes, correct.
Okay, I just have a couple of clarifying questions. Are you currently attending AA meetings?
Yes, I am, Your Honor.
And is it 3 to 5 per week?
It's 3 per week, and sometimes I have specific meetings that I really enjoy going to. So sometimes if I have time, I go to additional.
Okay, and you mentioned that you have coping mechanisms in place. Specifically, you mentioned wellness, running, self-help courses, how you handle stress. Anything else that jumps out at you besides those things?
Yes, Your Honor. My dogs. I really love my dogs. And my family. I have my grandma. She's 85 now. I really like spending as much time as I can with her. I have 2 younger siblings, so those are also supports, Your Honor.
Okay, thank you. At this point, I'm going to have closing statements from the parties, keeping in mind this is not an adversary proceeding, but we're here to make a record so that the board can make a good decision based on the facts of rehabilitation that have come out. So the burden of proof on this matter is on the petitioner. So if you want to make your statement first, please proceed, counsel.
Thank you, Your Honor, and I will be brief. I'm just referencing Title 16 of the California Code of Regulations, Section 1814, which is discussing the factors the board should take into consideration when considering this, their conclusion here. And I'm not going to go through each of them because I know you can do that, but I do want to highlight that this incident, while we are not making light of driving while intoxicated, did occur 6 years ago, and Ms. McKinney Morgan was fully compliant with her court-ordered probation and even was released early, and the matter was expunged. As a matter of housekeeping, I didn't see proof of expungement in the exhibits. If the court would like me to provide it after this, I'm willing to, and I apologize for it not having been included. Again, I'm not going to go through all of the items, but her rehabilitation is very relevant, and she has stated in her own words, which I'm not going to repeat, but her efforts towards rehabilitation and education, and really diving into an assessment as to why she was drinking at the time and chose to drive while intoxicated. And then that's it, at the risk of not being, I won't say more because I would be repetitive. With that, I conclude.
There has been expungement of the record, correct? I believe I may have seen a document somewhere that indicated that.
Your Honor, it has been expunged. We do have that petition, the granted petition. I have a photo of it.
Okay, and I believe there may have been such a document in the prior set of documents that were produced. So if in fact I find such a document, I'll include it with the petitioner's Exhibit 1. Okay.
Thank you, Your Honor.
Ms. Heim, do you have a closing statement?
No, I do not. Thank you very much.
Okay, thank you very much, Mr. DePoste. You mentioned that the board members may wish to take lunch at this point.
Thank you, Your Honor. So I have 2 proposals. Obviously, I would like to take in consideration our court reporter as well at their time. So we could take a 15 minutes break now and then only have a 10 minutes break between petitioners, or we can take 30 minutes break for lunch right now and go back and have 5 minutes between petitions. We started a little bit late today, so I'm trying to reorganize the time. So I would like to see any heads from my peers to see what they would like to do.
Okay, I'll wait for you guys to kind of resolve how you want to proceed.
Max, this is John Sovek. It looks like your connection has gone down a little bit. I would like to propose a 30-minute. I just think I need some time to be at my best for our next petitioners.
So it looks like Max's, you know, the bandwidth is very limited. So in that sense, being the vice chair, I will just take the, you know, take the advice to, let's see, take the advice to, to come back by, how about 12:35?
Ms. Wong, before you do that, is the court reporter still there?
Yes,
I
Your
just
Honor, I'm
wanted,
here.
I'd like to get an estimate from the number of pages.
Yes, Your Honor, the estimate is 44.
44 pages. And what's could I get your name and your CSR number?
Yes, Your Honor, my name's Julie, Julie, last name Granger, Granger, and my CSR number is 9201.
9201. Okay, so
Yes, Your Honor.
the parties will be provided a copy of the court reporter billing sheet that has that information on it. Thank you very much, Ms. Wong. Getting back to your request here, are we going to take 30 minutes then? That sounds good to me.
Sounds good. So we will be back again. Let's do just, 12, let's come back at 12:35.
Okay, sounds good. Thank you.
Thank you so much.
Okay.
Thank you.
Okay.